Professor Dr. A. Kumaralingam. So we will be beginning the section within 5 minutes. May I request all the discussants and speakers to come over to the stage? And this section will be chaired by Honorable Mr. Justice C.V. Ravikumar. And we are blessed to have Honorable Mr. Justice Manoj Mishra, Judge Supreme Court of India as the co-chair, and Honorable Mr. Justice T.S. Suriraja, Judge Supreme Court of Sri Lanka as the keynote speaker. Good morning, sir. Once again, a very good morning to you all. So our Honorable Chair and Co-Chair have just reached. I request all the dignitaries and panelists on the stage to please take your seats. Without much ado, we are directly going to the technical section. So today, we are going to ponder over the topic collaborative approaches and best practices in ecotourism, transportational law. One of the most pressing issues of contemporary times. And we have divided this theme into 3 sub-themes: ethical considerations and use of advanced technology, commonalities of law and practices in Commonwealth countries, standardizing technology adoption and collaborative approaches, Commonwealth best practices across sectors. So usually in every CLEA conferences, one session is dedicated to share the best practices across the Commonwealth. So today, this section is particularly dedicated to share the best practices in addressing the issues and related themes of ecotourism and transportational law. And the panel is rich with the esteemed presence of 3 eminent judges of the upper court of 2 different jurisdictions. We have Honorable Mr. Justice C.T. Ravikumar as chair, and we have Honorable Mr. Justice Manoj Mishra as co-chair, and Mr. Justice S. Raja as the keynote speaker. So we will begin the session with a formal welcome address.
Honorable judges, distinguished speakers, esteemed delegates, and dear colleagues. It is with great pleasure that I welcome you all the 3rd technical session on collaborative approaches and best practice in ecotourism and transportation law. The session is part of our broader theme exploring the intersection of law, technology and sustainability, all of which are critical to shaping the future of our society. Today we are privileged to have with us an exceptional lineup of speakers and moderators whose insights and expertise will undoubtedly guide us through a deep and thoughtfully examination of the ethical, legal, and technological consideration in these crucial areas. I am also honored to introduce our chair for this session, Honorable Mr. Justice C.T. Ravikumar, Judge Supreme Court of India, and our co-chair, Honorable Mr. Justice Manoj Mishra, Judge Supreme Court of India. Bring with them a wealth of the judicial wisdom and experience. Their opinion and views in this session will ensure that we discuss on these complex topics with clarity and enthusiasm. I am also honored to welcome our keynote speaker, Honorable Mr. Justice S. Raja, Judge of the Supreme Court of Sri Lanka. His address will undoubtedly set the stage for a meaningful exploration of the collaborative approaches and best practice that are emerging within the Commonwealth and beyond. As we discuss the ethical consideration and use of advanced technology, we will explore the shared legal practice across Commonwealth countries and discuss how we can standardize technology adoption to foster collaboration. These discussions are not only timely but necessary, as they will help us build frameworks that are both just and effective in addressing the challenges are ecotourism and transportation. Let us engage with the presentation and discussion with an open mind and collaborative spirit as we move forward towards a path that balances technological innovation with ethical integrity and legal coherence. Thank you all for your participation, and I look forward to this idea that will embrace for this session. Thank you.
Thank you, sir. So chair, co-chair, keynote speaker and all the speakers will be given 8 minutes time, and I kindly request all of you to please adhere to the time schedule. So it's my honor to invite Honorable Mr. Justice C.V. Ravikumar, Judge Supreme Court of India, who has kindly consented to chair this session today, to share his views with us. Welcome, sir.
A very good morning to everyone. I'll have to start by saying that I am not C.V. Ravikumar, I am C.T. Ravikumar. See, many years ago, a famous playwright by name K. Abbas, he gave a rightful caption to his, one of his articles. That is, I am not an island. That means human beings being a social animal cannot remain in isolation. I really wanted to borrow the expression, but at the same time use it in a different way. No country can be or can remain as an island. Because every innovation, every invention in one country, it has to be imbibed and implemented in other countries. In short, everything should be for the welfare of the mankind. I'm particularly thrilled to be on this panel to discuss a topic that holds mutual interest of entire humankind by virtue of its common impact on all of us. Definitely, I will have to say, in this fast-paced world, we often forget about the common ecology that binds us together, often forgetting that our advancement in various fields of law will be futile if you do not have an environment that supports the continuance of the balance that supports life altogether. Of course, I know that there is a caution already given by introducing 8 minutes. It is just like asking you something we are familiar with one Kathakali, a different art you may not be knowing. It is supposed to be performed in 4 days. Starting with the Nalajarita first day up to 4 day, and asking you to do it in 1 hour. So I will try my level best. I do not know whether I will be successful in that. Now it is, we will have to look into the topic for today. To start with, I think that we should familiarize with the expression ecotourism. The Commonwealth describes ecotourism. I will read it. It is like this. Ecotourism is responsible travel to natural areas that conserves the environment, sustains the well-being of the local people, and involves interpretation and education. And then there are certain principles which we are bound to follow when you are undertaking travels. The first thing, minimize physical and social impact. Second one, generate environmental and cultural awareness. Next is create positive experiences of both visitors and hosts. And then produce direct financial benefits for conservation. And the next 4 is find ways to realize financial benefits for the local people and private industry. Be sensitive to host countries' political, environmental, and social climates. Then construct low-impact facilities. Then recognize the rights and values of indigenous people and work in partnership with them. And of course, if you go through our constitution, of course, I use the expression Constitution of India. We will have to go through the provisions under the Articles 48A, stating protection and improvement of environmental and safeguarding forests and wildlife. Unnecessarily, the next article, that is, of course, Article 51 capital AG, which deals with the duty of every citizen to protect and improve natural environment. Similar enactments are there. Of course, my sister from Sri Lanka will be able to speak on that, enlighten us on that. And I'm sure that we'll have an insights on the sustainable and inclusive tourism practices belonging to that country. My knowledge is that Sri Lanka adopted a draft national policy on tourism for the period 2020-2025, if I am not correct. Then there are certain decisions only. I know that on these particular subjects, the experts are here. I need only to give some introduction, and I will not venture beyond that. Some pointers of case laws related to ecotourism of the Supreme Court of India. First, of course, everyone knows it is Godavarman Tirunulpar decision, that is in 1996. The Supreme Court emphasized that any development, including tourism, should not harm the environment or deplete natural resources. That is the sum and substance with respect to this particular subject, which was laid down by the Honorable Apex Court. Then, of course, the other one, next one is MC Mehta's case. I never want to explain everything because it is a time-consuming process. Then, in Ashok Kumar versus Union of India, that was rendered in 2003, Supreme Court held that this was virtually it was a significant ruling regarding maintaining a balance between tourism development and environmental protection. This actually was dealt with in that decision by the Supreme Court in Ashok Kumar case. Then coming to certain pointers, I have a big note here, but then to read it, that is why I said if I am to go through everything, I myself will consume half an hour. So I don't want to do that. I will state, of course, my co-chair, Justice Misra, may explain the other things. Now I will only say that standardizing technology and adoption and collaborative approaches in Commonwealth bus facilities across sections. There we will have to understand that tourism, it is not a topic to be studied in isolation. It is essentially a trans-sectoral subject that has its roots everywhere. A comprehensive approach that with the collaborative of tourism law, environmental law, labor law, cultural heritage, protection laws, economic laws, it all becomes cardinal to correctly come up with an appropriate legal framework to govern the field of tourism. I am sure that a beginning will done today, and because the very function, or rather the aim, the goal to achieve of this conference is to make a framework for this. Then the benefits of a standardization, sum and substance of the best practices should be tested on the parameters of, according to me, whether eco-friendly infrastructure is present or not. That we will have to ponder on that. Second one, education and interpretation to inspire responsible behavior. The third one, certification and standards. Next, regular assessment, monitoring and evaluation. The Indian Express, it reported that Costa Rica, the country Costa Rica, stands out as a prime example of successful ecotourism development. It stated that the ecotourism is renowned for its ecotourism initiatives focused on biodiversity conservation, national parks, private reserves, and sustainable lodges offer experiences like wildlife watching, canopy tours, and sustainable agriculture visits. So these are the subjects. Of course, many more it is there, but I think that my time, otherwise I will take more time. So these are the subjects which have to be deliberated upon. I don't know whether my brothers and sisters will be able to finish it within that 8 minutes time. This is a subject which requires more time. Otherwise, normally in a conference, you will have to go back with some kind of conviction. But then if you are doing everything within a time frame, instead of getting convinced, you may get confused. I never want that to happen. I think whether we are deliberating only on some topics, it is better to concentrate it and then get confused. No, get convinced. Thank you. Jai Hind.
Thank you, Honorable Justice C.T. Ravikumar, Judge Supreme Court of India, for setting the tone of the technical section so concisely but comprehensively. Also by taking us to various landmark judicial decisions and highlighting the cross-sectorial characteristics of the subject. May I invite Honorable Mr. Justice Manoj Mishra, Judge Supreme Court of India, to give us more insight on the issue.
Good morning to all of you. My brother has very succinctly put that the session should not be such that we land up confused instead of being convinced. So I'd like to deviate from the technical aspects because there are many experts who are there to deal with them. I would like to broadly describe what ecosystem could be classified for the purposes of collaborative approaches and best practices. Now, ecosystems can be divided into two. One is fragile and the other is non-fragile. A fragile ecosystem would be one where the damage is irreplaceable. You cannot repair the damage. Non-fragile is one where the damage can be cured. It can be repaired. In an irreplaceable damage case, we have to have very strong regulatory measures and systems in place. Now, for example, there may be forests and wildlife attracting tourism. Now, these are areas where the damage can be irreplaceable. You cannot repair the damage. So here the controls have to be very stringent and all best practices will have to be adopted. Now, for example, if you have tourism of hills, forest and hills are very difficult to replace. You can replace a forest in the plains, but not in the hills. So if you develop roads and an ecosystem to promote the tourism there, then that damage may become irreparable. So you have to choose the places. An environment impact study would have to be done in a very comprehensive manner, and that study must highlight those places which are fragile and those which are manageable. If those fragile places are being used for tourism and promoting it with tourism, then regulatory measures will have to be stringent. In such cases, you have to first collect statistical data. What is the mode of transport best could be adopted? Like if it is a place like Kerala, here water tourism can be, water transport system can be utilized. For example, if you travel from Vancouver to Victoria, you have steamers where you park your vehicles there and then you reach Victoria and then you can ply your vehicles. There's no bridge there. The bridge, if you have a bridge there, then there may be damage to the ecosystem. So what kind of a system would have to be adopted best for tourism would have to be determined in the context where that system is going to be placed in. So that is one aspect. Second is, while we are devising regulatory measures, we have to be bearing in mind the economic impact of them. Now, world, as we know, is a global village. When you ask a tourist operator which place would be the easiest within, say, a particular money budget, he would say Thailand is much better than India, because India you will be spending 1.5 lakhs, Thailand would be just 1 lakh. So this economic impact aspect will also have to be seen when we impose regulatory measures. We cannot have regulatory measures only to protect one side of the picture. You have to have a nuanced approach. Unless you have a nuanced approach and balance all the interests, not only of the people who are going to be impacted, but also the livelihood of the people, it would be very difficult to have an tourism which would be sustainable in the long run. The third aspect which I would like to highlight is the numbers which can be controlled. Now, if suppose you have a place like this place where the capacity to bear is, say, 1 million people or maybe 100,000 people, but you are having people much more in number, that would have a very serious impact on tourism and the environment. Now, how to control that? You can have variable tax regimes. Like suppose the taxation system is uniform. For all periods, you have a standard tax of, say, GST at 18% or 24%. That can be varied for prime time and for non-prime time. Like suppose you buy a timeshare in a resort, you will always find that there are pink zones which are getting the highest value and non-pink zone which don't get that value. So if the variable tax system is introduced, then you can divide the number of people all across the year, and that would help reducing the burden on the place which is hosting the guests. So these are the basic regulatory measures which can be put in place. So far as the general global impact of global warming is concerned, this again is a subject which is actually engaging attention of all experts and the entire globe in general. So it would not be really worthwhile in pointing out as to how we alone can contribute towards it, because this is a more global issue than a local issue. And ultimately there may be more beneficiaries out of global warming than those who are suffering. So for example, if there's a global warming, Russia would be having more arable land than anywhere else in the world. So would Canada. So there may be beneficiaries out of global warming, and there may be some who may be at the receiving end. So this is a very such a topic which has to have cooperation from all sources. So that is what I would like to say. Thank you.
Thank you, Honorable Mr. Justice Manoj Mishra, Judge Supreme Court of India, for your valuable inputs and also highlighting the need of possible regulatory mechanisms and the need for more collaboration and shared best practices in global warming. Now, it's my proud privilege to invite our keynote speaker of today's session, Honorable Mr. Justice Thurai Raja, Judge Supreme Court of Sri Lanka.
My dear brothers in the Apex Court, Honorable Attorney General for India and Honorable Attorney General for Fiji, my judges, brother judges, Dr. Vikram Singh Arya, distinguished academic and esteemed guest. Especially I have to mention Professor Lisa because she holds the time, so I hope she will give me another 1 minute little extra. Sorry for the scripted speech. Unfortunately, due to office, that we have to go for a scripted speech. First of all, I must say what an honor is to address this distinguished crowd that has gathered in Kumarakom today. Could there be a better place to speak about ecotourism than where we are right now? I think the longest lake in India, running up to 236 kilometers, thanks to Google. With a rich biodiversity and some of the most scenic view in India. Kumarakom is a perfect place, an example of what our countries have offer to offer the terms of natural beauty. Nowadays, the idea of sustainability has become buzzword. I must say the word sustainable is the word very much used and abused. But despite that, as the tourism industry recovers from the pandemic and related challenges, we now have a great opportunity to integrate these concepts of sustainable tourism and ecotourism into this recovery. For me personally, the topic be close to home. Since I come from a country, it is very much dependent on tourism. The history of tourism policy in Sri Lanka goes well into colonial period. The first tourism bureau was in fact established in 1937. Although the colonial rulers recognized the potential tourism industry, the World War became serious impediment in any progress. After Sri Lanka gained independence in 1948, the Sri Lankan government wasted no time in reviving the Tourism Bureau. Starting from colonial era up to date, it is no secret that Sri Lankan strategy always revolved around nature and culture-based tourism. The focus in Sri Lanka towards ecotourism is fairly apparent. The year 2000 was in fact declared by the Ministry of Tourism as Year of Ecotourism. My brother touched about the recent policy. There is a small hitch that the policy is pending before the Supreme Court, so I won't be able to comment it. The International Ecotourism Society defines ecotourism as my brother explained, responsible travel to natural areas that conserves the environment, sustains the well-being of the local people, and involves interpretation and education. Very clearly, the idea of ecotourism has, on one hand, an environmental aspect, and on the other hand, a cultural or societal aspect. In addition, it also associates itself with concept of sustainability. The two aspects, the environmental and societal, in my opinion, cannot be divorced. In fact, it is said that the word sustainability itself was first used in the 18th century by natural scientist Hans Carl von Karlowitz with regard to a forestry management in an economic context rather than ecological. One might say that humans in their infinite self-centeredness only cares to protect something when it benefits and befits their own. They might see this as a problem of flow. Perhaps what this truly reflects is a nexus between ecological, societal, cultural, and ethical considerations. Ecotourism as a sector recognizes the nexus of offering immense potential for economic growth while promoting environmental conservation. However, it comes with its own set of ethical and societal consideration. A very popular slogan when it comes to the nature-focused tourism tells us, leave nothing but footprints behind. The word footprints have various connotations. When we consider ecological and social implications in ecotourism or tourism in general, we cannot forget those connotations. We cannot forget the carbon and the economic footprints of ecotourism. If we were to take Hawaii as an example, it is one of the world's best known travel destinations and known for its very complex and sensitive ecotourism and system. Tourism, in fact, represents approximately quarter of its economy. Creating hundreds of thousands of jobs looks pretty great until you focus on the problems. Tourism greatly contributes to environmental degradation, and influx of tourists has driven up the cost of living, inflated the housing market, and also threaten Hawaii's cultural identity. The core of ecotourism policies lies in preventing such issues. by preserving the natural environment and respecting the local communities and cultures. It is crucial that tourism initiatives do not exploit natural resources and marginalize indigenous populations. To achieve this, we must embrace collaborative approaches and that involve stakeholders at every level, be it government agencies, local communities, private enterprises, and international organizations. Hawaii itself has now come to consider various laws and regulations establishing authorities to implement and administer initiatives concerning licensing and educating tourists about environmental and cultural sensitivities. Such regulation on the face of it may be an obvious and simple solution for all the problems, but of course, it becomes necessary to consider how such regulations might discourage tourism and adversely impact the tourism-dependent economies. Such economy dependency or similar consideration relate intimately to a state's ability to invest sustainable infrastructure. Transportation facilities and transportation laws plays a pivotal role in regulating the environmental impact of travel, particularly in the context of ecotourism. The challenges lies balancing the need for efficient transportation with imperative to minimize carbon footprints and other environmental damages. This is where advanced technology becomes crucial. This is where standardization and collaborative approaches become imperative. Standardization of regulations and technologies can enable collaboration by ensuring cross-platform compatibility, knowledge sharing, and collaborative approaches. Especially when it comes to research, development, and innovation can significantly increase the ability of states to invest advanced technologies by minimizing associated risk. In my view, it is very appropriate that this session turn its focus towards collaborative approaches and best practices. The success of any initiative in ecotourism hinges on collaboration between not only the governments but also private sector players, civil societies, and local communities. Commonwealth countries must leverage their shared legal heritage and diverse experiences to develop best practices that can be adapted across borders in different contexts. In conclusion of my address, developing best practices in ecotourism presents both challenges and opportunities. In navigating these challenges and opportunities, it is clear that collaboration is not just an option, but a necessity. The challenges we face, environmental degradation, ethical dilemmas, and rapid pace of technological change demand unified approach. We can ensure such unified, standardized approach through proper collaboration. As the organizers of this conference have promoted by bringing honorable judges, academics, and all interested parties and of various jurisdictions together. As final word, I wish to thank Senior Professor Sivakuma, who is the President of CLEA, for such a beautiful arrangements. As I said earlier, we leave nothing but footprints, and we take lovely hospitality of those who organized and such timeless memories. Thank you, Lisa, for mercy on time. Thank you very much, and have a good day. Thank you.
Thank you, Honorable Mr. Justice Suri Raja, Judge, Supreme Court of Sri Lanka, for deliberating on the integrated approaches towards environmental protection, ecotourism, sustainability, education, and collaborative approaches. The brilliant addresses of the chair, co-chair, and keynote speaker have aptly highlighted the ecological, societal, cultural, and ethical considerations and the increasing need to have respect and concern for the fragile environment and marginalized sections of the society who are heavily depending on the environment during our tourism projects. Now we have 5 speakers who will be throwing more light on the topic. Firstly, may I invite Honorable Mr. Justice Somashekar Sundareshan from High Court of Bombay.
Honorable Justice Ravi Kumar, Justice Mishra, Justice Turai Raja, Justice Dotto, the learned Honorable Chief Justice Govindan, the learned AG for India and for Fiji, good morning, Ayubhava, Bonjour, Bula. I'll do my best to stick within the time frame. Taking a cue from the topic, I set a stopwatch and a timer in my phone as a technological innovation. So I'll try and stick to time, ma'am. I just want to leave a few specific themes this morning. Yesterday, we had multiple references to Wayanad. And I'm glad Justice Mishra spoke about fragile and non-fragile ecosystems. The Western Ghats, which spans 6 states, from Gujarat to Tamil Nadu, right down. In 2011, there was a Gadgil report which actually identified 70% of the footprint as being fragile. In 2 years, it was reviewed by another committee, reducing it to 37%. Both reports were not acted upon across the governance systems of the states as well as the center, and we have what we have. So it's time for a wake-up call. It's a very important timing that we have to think about. But why Wayanad? Just 2 weeks before Wayanad, there was an identical development in Ankola, which is in the Goa-Karnataka border. Last year, there was an identical event in Maharashtra, the state I come from, where multiple villages were under a rubble. But I wonder what is the wake-up call that we would seek for. As we speak, there's a waterfall in Bhima Shankar, again a fragile eco-sensitive area and a place of religious tourism, as Justice Datto said yesterday, which has been shut for entry as we speak. This week they've said no more entrance. So we are actually, it's an alarming emergency situation we are in. Let's go a little further up north, away from the Western Ghats. Jyotirmat, which has one of the mutts of Adi Shankara, which was called Joshimat earlier, now Jyotirmat. The city we had a new word in our vocabulary called subsidence, where the city was sinking into the earth. The causes were manifold. We don't know the real scientific final view yet as to what it was, but rampant construction, heavy footfall, these were the things that were said to have led to what happened in Joshimat, an entire city sinking into the earth. But what is alarming is that the geological profile of Joshimat, identical profile is found in Nainital, Uttar Kashi and many other places which are known to be very, very important destinations for tourism. So against this backdrop, some points I want to leave behind. When we speak about sustainability and intergenerational equity, we bring with it an aura of being moralistic or altruistic. The point I wish to drive is this is no longer intergenerational equity. It's an intra-generational equity issue. All the episodes I've spoken about are episodes within the last 2 or 3 years. So why pitch it on an intergenerational zone? Is actually within a decade that these things are happening, and we need to have a serious consideration of it. Towards that end, I want to say that we need to examine that if greed and fear are the two drivers of human conduct, most of us think of law as driving fear, but let's harness greed. Is there an ability to make communities and tourists see the incentive that they have a vested interest in sustaining these fragile ecosystems? If Switzerland, for example, the ecotourism policy in Switzerland was about making people realize that they have a vested interest in long-term sustainability of the environment. And that's how Switzerland is what it is today. So is there a way for us to look at, be it the Western Ghats from the Sahyadris to the Nilgiris, or the mountainous regions of Himachal or Ladakh, or the riverine states like Uttar Pradesh or Bihar, which is with the Nepal border? Can we look at how we can communicate that it's in the vested interests of the communities, the tourism industry, the tourists, the travel industry, that a long-term sustainability of these ecosystems is vital for the future. We do have a subcontinent in India. It's not a Switzerland, it's not even a Singapore in that sense, but it's a very diverse subcontinent. We have a range of topography, range of ecosystems, which leads to the cultural diversity, in fact. But even if we take just 5.5% of our population to be poor, we need to pull them out of poverty, and therefore development is very important. Therefore, I wish to submit that development and sustainability are not antithetical at all. We can find a way to harness the two. We do need development, but what is the modality of that development and how do we make it sustainable is something we need to ponder about. What works in rapidly developing the plains in, say, Gujarat or Maharashtra will not work for rapid development in a Himachal. So the point I wish to make is we need to work bottom up. There has to be pre-policy consultation, forget pre-legislative consultation, even before formulating a policy, active involvement with the local communities, with the local industries, which feeds into how do we deal with what we have to do for that region. Towards this end, I want to give two examples. We had the case of Udaipur. Udaipur, we have our brothers from Rajasthan. It's known as a city of lakes, but if the lakes were drying up, the tourists were drying up. There was a very simple shift in policy that was done. Give priority in water policy to the lakes as opposed to agriculture. This can sound shocking to anyone who says, oh, India is an agrarian country, but Rajasthan was an arid state. So agricultural use of water would have been suboptimal, so it was felt the tourist use of water would compensate for it. We can import produce, agricultural produce from outside Udaipur. So the priority was given to filling the lakes up and ensuring the lakes were always full. Take the case of snow leopards in Ladakh. The villagers would kill the snow leopards because snow leopards would come and take away cattle. A policy was developed to say if a villager loses cattle, he'll be compensated for that cattle. Concomitant with that was a homestay policy enabling the villagers to create homestays so the tourists who would come looking for snow leopards would be able to stay in those villages, and the villagers would earn far more with a live snow leopard than a few dead cattle from snow leopard attacks. It has transformed the topography in Ladakh and Himachal. Today we have 700 snow leopards and an enormous footfall of ecotourists in these regions. One last point I want to make before I conclude. Yesterday we heard a lot of clamor for regulation, that we need to regulate. This is a very simple phrase to say it needs regulation. But we need to think through from the grassroots, what do we mean by regulation? We are a country which has had a long history, about 6 decades of control as opposed to regulation. And very often, even today, even in sophisticated market regulation, control passes off for regulation. So as Justice Mishra said, I think it's need for empirical data collection. What do we need to regulate? What is the areas that we need to do? Is licensing a form of regulation or is it a form of control? These are discussions to have at the macro level. But none of these would be relevant unless we gather data from the grassroots and create solutions that are specific for those regions. A Udaipur solution for an Udaipur type area may simply not work in a agrarian village. So you have to find customized, bespoke, tailor-made solutions, and any regulation would need to be something that enables creation of such an architecture. And that's all I want to say just now. I hope I've stuck to time and left some food for thought. My alarm timer is going off. Thank you.
Thank you, Honorable Justice, for alerting the gathering to critically scrutinize the vested interest of the tourism industry through the prism of sustainability, intergenerational and intragenerational equity. May I invite now Professor Dr. H.J.F. Silva, Vice President, Commonwealth Legal Education Association from London. Sir, please.
Good morning, everyone. Mr. Chairperson and all the distinguished panelists on the dais, distinguished delegates. and everyone present here. I must first thank Learned Attorney General, Honorable Venkataramani, and my friend Professor Sivakumar for the invitation extended to me to attend this conference in this beautiful setting, an opportunity which I would have never had. I am so pleased that I had this opportunity, and I thank you profusely for the invitation and the warm hospitality I received here. They treated me like a father. There were his staff who was looking after me very well. Thank you very much. To begin my speech, I must say I am no expert on this topic. In fact, I was wondering whether I was in the wrong place. But however, I learned quite a lot yesterday and today. It was really an educative process for me. What I learned was the conflict between sustainability and development. In fact, one of the speakers yesterday spoke about balancing of conflict of interest. And in fact, he referred to Roscoe Pound. How do you balance this interest between this sustainability on one hand and development on the other? Thinking of this, it reminded me of a poem by a writer and a novelist called, some of you would have heard of her, Isabel Allende from Chile. She is a niece of, I think all of you must have heard of him, Salvador Allende, the assassinated president of Chile. She writes in Spanish, but a loose translation of a poem goes like this. When we were hungry, we killed an animal. Then they called us savages. But they came and killed our animals in their hundreds, and they called it civilization. We cut a tree to provide shelter for us, to build a hut. They came and felled our trees in their thousands and destroyed our forests, and they called it development. So this is the conflict, right? People want sustainability, and then at the same time, there comes the development. She is very passionate about these issues because her uncle, Salvador Allende, was assassinated by various interested parties. And she writes about the issues of development and sustainability. So she puts that in the form of this poem. Now the Spaniards came to South America, and they started exploiting the place, completely destroyed the famous Inca and Maya civilizations. Same thing so many years ago, Vasco da Gama arrived somewhere very near, I think, Code, and then start a different phase of development, so-called development. So in spite of how do we balance these things? Now, Madam Moderator, please stop me if I say something very controversial. To have this balancing of interest, there should be a balance of power. When there's a giant among dwarfs, it is the giant's law. Giant's law applies to the dwarfs, not to the giant. Giant is above the law. Now, if you look at various conventions on environmental protections, you find the giants, they ask the others to follow it, but they don't follow it. So these are the things that lead to various conflicts. Have you ever thought about environmental damage caused by various proxy wars that are going on? In fact, I'm no prophet of doom, but say we are on the verge of a nuclear war. We don't know at what time it will happen. So before we have development, tourism, let us now also pay a little attention for world peace. How can we achieve world peace? It is like the fight between this biblical story of Goliath and Samson. But ultimately, Samson won. Why? Because the God was on his side. What is God here? God is justice, dharma. Now, it was mentioned yesterday. There is what, especially from this land of India, where the concept of dharma originated, Sanatana Dharma, the higher law. What is happening today, this higher law, that is justice, fairness, is forgotten for material gain. So how do we balance this in the light of this one-sided power conundrum? What do we do? What I suggest is, in our little way, we must try to promote this Sanatana Dharma. Now it started here. If you look at Asokan edicts, the inscriptions, where he talked about not only of human rights, but about animal rights as well. Give me just 1 minute. Animal rights as well. So let us now try to revive these old treasures we have of ancient wisdom and try to promote Sanatana Dharma. That is the only way we can achieve world peace, prevent this world from being destroyed. Thank you very much. Have a nice day.
Thank you, sir, for your address. Your views on Dharam, world peace, Sanathan Dharma, animal rights, and balancing the conflicting interest of development and sustainability, which was simplified through your short poem, was very well taken. May invite now Professor Dr. V.C. Vivekanandan, Vice Chancellor, Hidayatullah National Law University, Raipur, and Executive Member, CLEA Asia, to deliver his address.
Honorable Chair, Mr. Justice C.T. Ravi Kumar, Honorable Co-Chair, Mr. Manoj Mishra, distinguished jurists on the dais, off the dais, and the discerning audience here. It's a bit of a human rights violation asking an academic to wind up in 8 minutes of a topic of this nature. But I'm under the jurisdiction of the chair, who happens to be also under the jurisdiction, is a visitor of Hidayatullah National Law University. So keeping that in mind, I will try to get you a view about this topic, little complex topic, but I will restrain myself to the first part, that is talking about advanced technology, which basically is about AI. So, yeah. So if I look at the quote, which I'm never tired of talking last 25 years since I started teaching on internet law. We are approaching the new era with 21st century technologies, with 20th century governing process and 19th century governance structures. This is said in the context of US, but I think it applies here. I think recently we changed the criminal laws, which was also from 1860. We call that as new criminal laws. So otherwise, still contract law is 1872, and many things are there. And governance structures, we are, I think, more or less, except with few exceptions, all are post-independence, governance structures in the mind, our process. But we are talking about tomorrow's technology. Every day we talk tomorrow's technology. So let us understand the complexity of this. Or in other words, the journey from Flintstones to genetic clones is a human history, is nothing but technology history in a way. The relationship between law and technology is a constant in history. Technologies keep changing. The town mayor today, I am talking thousands of years back in Flintstone, first time ordered, you should give a license to Flintstone because somebody set fire to some place with the Flintstones. So law starts and the regulation starts. But technology is relentlessly continuing and we are, in a sense, a step backward. So the last decade saw the frontline countries of US, UK, France, Japan, and China surging ahead with the national policies on the future footprint of this concept and imagination called AI. India, considered as a frontline soft power on technology and human resource, also came out with Niti Aayog, the think tank, talked about AI for all, probably a Benthamite concept, greatest good for the greatest number, was the kind of race which advanced technologies are moving. But if I put the number crunching, India will spend about $6 billion on 2027, whereas the global AI spend is around approximately 512 billion by the same time. India is ranked 14th in the paper contribution, which is 1.4% of the global share, whereas US and China are contributing to 30.4 and China 22.8. Means India has to do a lot of catch-up in the so-called advanced technologies. Probably that's why Government of India in the recent budget has allocated a massive thing towards AI to do the catch-up game. These are the latest sources. But if I look, the buzzword, it has multiple definition, which means it has metamorphosed as machine learning, deep learning. The functional competency of AI actually is about replacing humans in various facets. That cannot be left out in the mind. So technology is a constant, as I said. When you taught dogs to sniff and you put drones in the sky, there is always technology coming. It's new at every new point. But I said, the burden is for the law and regulation to manage it. And that is a crucial point. It's technology first, and then the regulations law comes next. As one of my senior colleagues used to tell, it is like a Hindu marriage, where the husband is the technology and the wife is the law 7 steps behind, used to tell. And he used to warn at least 7 steps they should watch if the husband should not vanish. So that is one point which you have to keep it in mind. So what is the thesis and antithesis of advanced technology in our day-to-day life, be it ecotourism or transportation? It's about creative and destructive abilities. Its creative abilities in health, education, transportation, ecotourism, communications count on. The destructive ability ranges from displacing labor, weapons of selective annihilation, or even selective targeting. That is the flip side to that. So the creative ability is about precise decision making from mountains of data, whereas the destructive ability to shave off those who cannot afford it or who will fall in the crevice. And this is where I consider our fraternity is looking at both. How do we really manage this? So if I say science, technology, law, the trilogy, the core question for science is always why. For technology is how. For law, for whom. That is the crucial question when these three professional things come together, each one looking at a different perspective. And so if I say the boon and bane, the boon, as I told you, business analytics, precise health focus can be done. Expansion of education is already happening thanks to AI. On-time justice delivery system is happening as people, it's not, courts are not something very mysterious place. Everyone sits in their handphone and watches as the case is unfolding in front of them. The bane part is labor displacement, surveillance, and selective targeting, and there can be many more which may happen. So, how do we interface, which I am coming to the end of that, my presentation. ecotourism, if I talk, it's a delicate balance of technology and ethical consideration. The core of ecotourism is to balance larger public interest to travel and visit, and also the nature on the other side, and also local communities. That should not be forgotten. So when you are looking at opportunities window, drones can really talk about wildlife monitoring, and it can also talk about data analytics and choices and spend of visitors, and so that we don't have, sometimes we see this massive rush happening in, I was seeing in TV yesterday, 4 or 5 days of holiday, so people are massive rush, traffic jam, and all kinds of problem. Probably some level of AI could really give us data understanding how to do. But on the other side, when I say the challenges is disruption of natural habitats can happen because of AI, as well as data privacy of consumer and unintended consequences are there. And the winner takes all. That's a big problem of big technologies. Of course, 5, 6 companies control AI throughout the world. So winner takes all. And there is no second, third, or consolation prizes. So you're really talking about what is the involvement of finally local communities. Are they also part of a beneficiary of this? This is the point. So the interfacing, as I said the last slide, the liability issues of AI in transportation. We all know the liability issues. Who killed the cat is the famous phrase. The dynamic fares, rationale and impact. I happened to go to 6,000 to 7,000 rupees from Hyderabad to Raipur. 2 days back when I went to click, I want a ticket. It showed me 32,000 rupees from Hyderabad to Raipur. Means I'm upper middle class. I said my dilemma was to postpone my trip. I can understand many people, nobody still knows AI-driven dynamic prices. It has been raised in Parliament also. It's high time there is to be regulation, because it's not the question of highest bidder. Let me tell you, transportation, whether ecotourism, other is a fundamental right. So one has to really look these issues, and people say nobody knows because there is a software and a code which is managing everything. And so, as I said, that efficiency versus employment displacement is all the thesis, antithesis, or the paradox. Traffic management versus surveillance. So, but not to throw the baby out of the bathwater. In fact, I believe that artificial intelligence can never supplant these uniquely human endeavors. It can augment but never replace the innovative things. We could have heard our Honorable CJ speaking. He couldn't come. I thought his quote, I am putting it here. So, how far ethics can go from Kumarakom? I think that's part of the CLEA to look at the conclusion of this type of very intricate topic. As I said, is it time for an AI regulatory commission? One needs to seriously look at it. Thank you very much.
Thank you very much, sir, for your address, enlightening us to decipher the constant interface of law and technology by exploring the thesis and antithesis of technology, and also by raising core legal questions of managing and regulating the technology without compromising the human rights. May I invite now Mr. Rohan K. George, partner from Samvant Partners.
Good morning to all those gathered here today, to this respectful audience. I thank you for the time you've given me. I'd just like to make one clarification. Over the course of the last few months, I have decided to focus more on the exploration of not the law per se, but the application of new and emerging technologies to the law. And I would like to confine my presentation and the subject of my presentation to this particular topic. So in that context, I had prepared to talk about the impact of artificial intelligence and the potential disruptions it may face in the legal sector itself. I have been promoting an organization called Ad Item in that particular context, and I have been exploring the directions in which the legal practice can, on some level or other, be revolutionized by AI and other tools in this context. So to begin with, I think we should accept a certain fundamental premise in almost all other professions, the use of technology has been a given. There is no practice of medicine without technology. Since the mid-80s, the practice of accounting is inseparable from the use of tools like Tally. And in the area of, for example, architecture and design, it is impossible to begin a course without first teaching matters such as CAD and 3D modeling. The current state of play about matters in technology in the legal profession and the few things which have actually disrupted it have been MS Word, which has been something which is introduced somewhere about 3 decades ago. It may be strange to think of it as something which disrupted the legal profession, but one will recall that there was a time when the entire efficiency of lawyers' office was built on their secretarial pool, which consisted of people who could type very fast amounts and make sure that those were submitted for pleadings, documentation, or anything else. Today, a lot of those functions are acknowledged as being achievable with a single lawyer with a laptop. It doesn't look disruptive because this is the new normal, and we have been in that normal for some time now. The other significant change has been online legal databases, because once again, a conception of what a lawyer's office would look like was at one point inseparable from these huge tomes which surrounded us at all points in time. Today, that lawyer's office on all those tomes and even more information is contained within a fairly small device or capable of being accessed using a fairly small device. So these are disruptions which have occurred, and it is my argument that we are on the verge of another technological disruption in the form of artificial intelligence. We have seen some examples of this come out in the recent past. We have walled gardens tools, which are basically very specialized, hyper-focused tools, which have tried to utilize this. And therefore, it may look to us like this is not something which is a major concern, because you have tools like Luminance, which are available for about £1,500 per month for a very specialized group. They provide contract intelligence and allow people to actually generate contract analytics, talking about which particular contracts and which clauses have been successful or not successful in which contracts in the past. You have CLEA, which is practice management, which still costs about 120 users per month. And you have specialized tools for patent drafting as well. But the new wave of artificial intelligence has the potential to disrupt legal services in a way, I would argue, significantly for the better. What does this new wave consist of? Let's first understand large language models and the sort of AI technology, which is in no way arguable as being artificially intelligent, but creates abstractions of human language processes in the same way that a spade or a lever is an abstraction of a human physical process. In other words, when we want to administer a checklist examination of a legal document, we no longer have to necessarily apply a human being's labor towards that rote task, but we can actually automate that using machine learning tools. So this provides incredible potential for access to legal services, a chance to flatten the curve itself, a chance to accelerate turnaround time for documents and make sure that things move faster within every stakeholder itself, a chance to provide analytics and give people actionable information about what is working and what is not working. So in other words, there is potential for AI to actually help. And one of the few places where people can really see AI's impact on law is in the context of contract drafting. In this, we have probably come across tools which have been either shown to us or marketed to us for creating contracts generated from context and not templates, ways to get to your first draft within minutes, not hours, and allow easy automation of contracts with minor clause changes. There are companies like Spellbook, Harvey, and Robin AI which have been providing these for some time now. In the context of our enterprise, we have developed a tool as well. It is basically capable of working right out of most lawyers' favorite online space, which is MS Word, and using AI which integrates with your documents and lets you handle details and basically create a document straight from the context itself. The other element is the idea of automating compliance. Privacy policies and the DPDP Act are something which a lot of normal people are going to have to interface with. It's not something that only massive companies will have to deal with. Anyone who has an online presence will have to be concerned about that. But using large language models and AI, it is possible now for us to envision a situation where someone need not necessarily have to take the entire review of the privacy policy through a lawyer, but can get a significant part of that automation done through a large language model. We worked on a tool on that to that effect and have it in production to some extent or the other. And finally, with regard to disputes assistance, a problem which plagues both the bar and the bench at all points in time is the size of a dispute's case file. And being able to manually manage and analyze this case file is an extremely time-consuming affair. It can either take up to 4 hours for a case file, or it could take a week for a case file, depending on the complexity of the matter. But at the bare minimum, I think we can agree that getting a handle of a case file is a matter of hours. What we have developed is a tool which takes all the aspects of a case file and allows you to develop an understanding of this case file. I'll walk you through a very brief video. It allows you to just take a bunch of documents, upload them,
respondent pleadings, a building agreement, bank transfer statements, and correspondence. All this relating to a dispute between a construction company and the owner of a property.
So this is an approximately 40 document case file.
Easy and intuitive to use. Simply navigate to the folder containing your dispute case file, select the documents and upload them. Click the tags and we're set. Let's start our analysis. One of the easiest ways
What it generates here
of the dispute
is what we consider to be briefing materials for a dispute. A list of dates,
requires someone taking at least a few hours
a
to go through
timeline,
every document in the case file and generate a comprehensive timeline. With consensus, we're able to create and view this timeline in minutes. This timeline features a comprehensive listing of all the key dates and events in the disputes, pulled from every document in the case file. An important feature of consensus is traceability, ensuring any insight generated by consensus is backed up by a reliable source of information from the case file. In the timeline, this traceability is built using the View drop-down. This allows you to review the relevant language in the relevant document from the case file that references this timeline event. Another way of getting a high-level understanding of the dispute
another aspect is the summary of the pleadings itself.
In this summary, consensus breaks
So in
down the
addition to
entire
an examination of those documents, you're also able to see a summary of the key issues of the dispute, as well as a summary of the actual inconsistencies made between a party and the pleadings themselves, and also in framework be able to generate pleadings. I feel that this and various other advances in AI technology will make a significant difference to how we see legal practice today. And the issues, of course, can involve hallucinations, can involve intellectual property and such like, but there is a way to take this to the point where with proper refinement, these can actually be aids in our legal process and not necessarily hindrances. I'm out of time, so I thank you for your patience on this. Goodbye.
Thank you, sir, for that thought-provoking address, touching upon the mood and boon and bane of AI, its intricate and complex issues, which might even disrupt the legal services if not used prudently and wisely. May I invite Ms. Sariga Pandabhat, Founder Trustee, Ragiri Foundation, to address the gathering.
Excuse me, presentation. Yeah, good morning, Chair, Co-Chair, Honorable Judges, Attorneys, and ladies and gentlemen. Thank you for giving me this platform to actually talk about, from last 2 days, many of the speakers discuss about road traffic crashes, fatalities and injuries, and how there is a huge gap when it comes to judgment. I just want to highlight few things around it, and also how it impacts our mobility, and when we talk about tourism, how it impacts tourism also. So by the time we will finish our conference, this 2 days conference, India will lose almost 900 people. Basically, 900 people get killed in road traffic crashes in India in these 2 days. So basically, every day 60 people get killed, and hourly it's like, by the time we finish our session, 40 people have been killed in our Indian roads. So and if you see in terms of criminal cases that been lodged across India, 50% of them are road traffic crashes. But it is the most neglected area, and it's a bailable offense. So I call it that it's the invisible Indians who die every day, and no one cares, and it becomes another news article. And if you understand, India has 2% of motor vehicles, but address to 13% of road traffic deaths and injuries. It doesn't, many times people argue that the vehicles are growing, that's why a lot of deaths happening. That is not true. It is also leading cause of deaths and injuries between the age of 18 to 45. That means we are losing the youth of our country, only breadwinner of the country, and also we are losing 3% of our GDP because of this. So India is fairly bad on addressing this problem. First thing is that, it's no one's problem. It's individual who died or their family. Also, empathy. There is no empathy for another road users. If you are sitting inside a vehicle, we hardly respect a pedestrian and cyclist who is using the road. Also, very poor road infrastructure. Yesterday, there are a lot of discussion about if we are having autonomous vehicle or other kind of AI system, are our infrastructure ready for that? Of course not. Also, we are not developing our cities and towns as for people. We are creating highways inside the city, which is leading to all these deaths. We need to focus on moving people and not vehicles. That is what we need to do. Also, low penalties, as I mentioned already. If you see the cities who have high number of tourism across the globe are the pedestrian-friendly city, where you can walk, where you can use public transport system. That is where you see there is huge number of international and national tourists are going. Also, that is because people are walking, cycling, and using public transport, the air quality is also very good for people to go and enjoy their vacation. I'm just skipping because of the time. This is one slide I want to highlight. So mobility or road safety is not one department's problem actually. So there are multiple departments who are involved or who are basically to be blamed for not having that kind of infrastructure. But what we need, yesterday we talked about a lot of regulation, as sir mentioned, but there are very less regulators. So that is also one of the problems. There is no nodal agency who can address this issue. For example, traffic jams, police is focused on traffic jams rather than, saving lives, reducing road accidents. That is why it is called traffic police. There is no road safety police in our country, when many countries have. So what we need is a very strong national road safety board, which is important for our country. And if we are not addressing this, then we need to transfer human bodies like this is what we need to convert our body, which can resist, crashes. Way forward, as the topic is, community engagement, top-down approach, and best practices. I just want to share two of the best practices that our organization is working. One is this program called Haryana Vision Zero. It's basically Vision Zero. It's like zero road traffic deaths, and that is the acceptable number. Not even one person should die in this road crashes. And why? Sustainable mobility plays an important role to reduce this road traffic deaths and injuries. So this is one of the best projects in PPP, where private organizations, civic society groups, and the state government came together to work in this project, where it was data driven, where there were a lot of research about how to reduce road traffic crashes and injuries, which is again, it is lacking in India because we are not focusing on research-based development. Again, sir was highlighting that, we cannot copy paste. So we need to do research-based development, and that is how this program has been worked in Haryana, and where we were really able to reduce 10% of road traffic fatalities and injuries, which is actually saving 1,500 lives in 1.5 years. So moving forward, what exactly we need to do? We all know what needs to be done, but how we have to do is a question mark all the time. So how we can do is actually we need to develop people-centric mobility, which can boost tourism also and which can save lives also. So another project I just want to highlight as a best practices. This is one of the street in Gurgaon where there are a lot of urban villages and almost 25,000 people walk in this street, and it's an industrial area, so they go to different industries. Lot of women walk in this street in the night also. So earlier the government's plan was to cut all 4 fully grown trees, 500 fully grown trees, and widening the road for vehicles. But again, the citizens group, our organization and government came together to save all those trees and create a beautiful walking and cycling path in the street. Also reduce heat island, also reduced urban flooding. Also, there is 0 traffic fatalities and injuries in this street. And women are actually walking safely. And women workforce has increased because it's properly lit. There are eye on street, there are natural surveillance. So women are actually, walking safely in the street. When we were talking about using boats in Gurgaon and Delhi yesterday, so when the entire Gurgaon, the city was submerged with urban flooding, this particular street, which has focused on nature-based solution, was recharging entire rainwater, the rain swells that has been developed. You can see with dignity the pedestrians are walking in the street. So there is no water logging, 80% water has been recharged, and again, it's safe. So this is, I want to say last thing that, development is important, but what we need to also focus is that let's not do the worst kind of development which can crash our lives. Planet will be here, planet is not going anywhere, trees will be here, earth will be here, the humans who are going to suffer because of this climate change, not the nature. So thank you so much.
Thank you, Madam Sarika, for addressing the issues of sustainable mobility and people-centered mobility to boost tourism. You have unearthed the unspoken stories of road safety with eye-opening data and sharing the best practices from our own country, such as Vision Zero and from Haryana and Sanans Road of Gurgaon. Now we will be moving to discussions, and I know that confining your addresses on such a crucial issue to 3 minutes is highly impossible, but kindly adhere to the time frame as initially framed by the organizers. So we will listen to Honorable Mr. Justice P. Sam Koshi, Judge High Court of Telangana. All discussions will have 3 minutes.
Warm good morning to all. The Honorable Chair, Justice C.T. Ravi Kumar, Judge Supreme Court of India, Co-Chair, Justice Manoj Mishra, Judge Supreme Court of India, Honorable Justice Dipankar Datta, Honorable Justice Prashant Kumar Mishra, judges from the Supreme Court of India, my brother Judge Somashekharan from Bombay, all my other brother and sister judges. I was just wondering what is left to be discussed after 1.5 days of brainstorming, discussions that we have already undertaken. And as a discussant, with the limited time that has been given to me, that is of 3 minutes, and that is on a topic which is as wide as it could be, And practically since yesterday, everybody has admitted that it is just simply not possible to restrict ourselves with the limited time that is provided to us. Nonetheless, what I would like to draw at this juncture is, when you talk of sustainable tourism with transportation law, which in other words is inextricably linked to each other. But at the same time, what is also to be required is, what is the level of sustainable development that would be required at one particular area. Let us talk of one tourist spot, and we have gathered here at a time when Kerala has faced a massive catastrophe at Wayanad, which again is one of the most sought after tourist spots in India in the recent past. And when you talk of sustainable development, the first thing that in my view is, we should draw a line as to what is the level of development that should be permitted. Let us talk of Wayanad at Wayanad. And if, I'm sure many of us have already been to that place as a tourist, when we visit Wayanad, we see beautiful resorts right from the bottom of the hill right up till the hilltop. Every resort into hundreds of acres. Think of the activities that made the tourist spots that attractive, these resorts that attractive, the amount of construction activities that was taken into in the course of establishing that resort, the amount of natural damage that was caused for the establishment of the resort. And at the end of the day, for the tourist, it provides for the best of road facilities. Now when you look at it, you get wonderful roads up till the hilltop. But how was the road constructed? What was used in the construction of the road? Metals, of course, bitumen. And now from where do we extract metal? Quarrying people, they damage the ecosystem. The entire quarrying industry in Kerala has been one of the root causes for all this. The amount of pollution that has been caused in the course of use of bitumen, is it really worth at the cost of the recent catastrophe that we have faced? Are some of the challenges that we need to know, we need to understand. Today we'll be passing a Kumarakom resolution. I sincerely hope that this would be one area which would be taken care of by the organizers. The amount of deforestation, the erasing of hills, erasing of hilltops for the purpose of taking the transportation for the establishment of the resorts. As I said earlier, we need to ponder, we need to put a limit to the extent of the resorts, the extent of hotels, the nature of the hotels that have to be established in these natural areas, whether we permit concrete structures or whether we permit, when we talk of ecotourism, to have hotels, huts without the use of concrete or other materials. These are some of the areas which I would like to share at this moment with the limited time that I have. Thank you.
Thank you so much, sir, for talking about the sustainable tourism, wherein you have thrown light upon the deforestation and erasing the hilltops for development by taking the Wayanad example. So which is really sadful, and also which makes the conference all the more meaningful, because this is the right time to think about the development that is unthoughtful of the sustainability and the human lives. So I think the best example from yesterday we have been taking up by various persons and from the inaugural session itself. So this will give us the best opportunity to capture the issues and to find the best possible solution, so that in future we will never face such a disasters. So may I request now Honorable Srimati Justice Josna Revel Dua, Judge Himachal Pradesh High Court, to address the gathering.
Honored guests, esteemed colleagues, ladies and gentlemen. Today's topic for the third session is best practices in ecotourism and transportation. I'll discuss this topic with perspective from my state. I come from a mountainous region where there are no waterways. I hardly know the meaning of the word airways. I'm still admiring my old toy train of the British era. I long for the modern system of transportation to come to my state. However, I'm very well aware about the necessity and the nuances of building good road infrastructure for promoting tourism. Augmentation of road, 4-laning, double-laning, widening, these are all policy matters. Those who have been to Shimla, Kullu, Manali, Dharamshala in recent years might have witnessed that previously roads used to remain blocked because of clogging of vehicles. Now also roads remain blocked. The reason is because of angular cuttings of mountains, because of lack of adequate finances, because of lack of adequate preventive measures. There are landslides, and massive ones at that. The big mountains keep coming down to meet Mountain Earth every now and then. The existing laws, the NH Act, the Land Acquisition Act, the local laws are not adequate to deal with the problems which we are facing in our state. As it is, the developmental projects are not usually stalled. But when one sees the damage caused to the ecology, the flora and fauna, when one sees the complaints of the people visualized at this spot, damage to their land and property life, when one sees the dust all around, when one sees whole state dug up in the name of widening of road, one really starts wondering, was it really worth it? When you go around the world, you see modern technology being used, wire meshing, the nailing, shotcreting, etc. In my state, you don't see that much often. You only see breast walls up to 8 feet height, and above that, the mountains are all bare, open to landslides. So moral of my first story is that we need not only the, when you conceptualize a particular project, at that time, the aftermath of the project, what is required to be there, the preventive measures which are required to be in place, and the budget, adequate budget for that is also required to be put in place. Otherwise, the fate will be like which we are having right now. We are resigned to fate to live with the wait for mountains to 20 to 25 years so that they can stabilize. Now, my second story is that yes, ecotourism, ecology has to shake hands with tourism. Now, my once sparkling blue, green, glacier-driven rivers are now all muddy waters. They are crying out for breathing. They want dredging. They have become dustbins. Even dustbins needs to be emptied. They are not being emptied. The other day, we asked the state government to please carry out the dredging. State said that no, it is not within its domain. Please ask the central government because it is forest land. Central government said it can't do dredging. It can only give permission. Please go back to the state government. We can give you permission. Now, state government says, we don't have the wherewithal or the budget. Please ask the executing agency to carry out the dredging. Executing agency says it is not within the domain of its contract, neither it is responsible for the damage caused to the river. So please go and ask and find the culprit. We have traveled a big circle. So moral of the second story is that not only the regulatory framework, the legal framework is to be there, but that framework has to be such that it doesn't create bottlenecks for its own implementation. Now, let us go to my third story. Of course, road infrastructure has boosted the tourism. I collected some data. From January to July this year, number of vehicles which crossed Shogi about 10 kilometers from Shimla, that was around 12 lakhs. In the same period, the number of vehicles that crossed Atal Tunnel to Lahaul Spiti was, can you believe it, 20 to 25 lakhs. And we talk of carbon imprints, foot imprints, etc., etc. So what is required is, and how it has impacted Lahaul Spiti. Lahaul Spiti is a once quiet, small, sleepy town, sleepy district, snow-clad district. It is now looking at the world with wide, bewildered eyes. It doesn't know what to do with so much tourist influx. What has it done is homestays coming up in mushrooming numbers. There is no policy in place. Policy which was framed in 2006, it hasn't kept pace with the increase in the tourist influx. So law is also required to be audited. The pace is to be, with the pace has to match the pace with the influx of the tourists. Number of vehicles to Rohtang was restricted to 1200 per day with 500 green tax, but the number of vehicles crossing Lahaul Spiti has not increased. It is that only. And with increase in tourists, we have now paragliding World Cup coming up. We have river rafting, we have mountain trekking. We've got all these things coming up. But the laws, regulations are not that much, and whatever is that, the enforcement is not to that an extent. We need court orders to ask the tourists to become responsible tourists, to carry your trash cans in your vehicles. Don't throw it around the road. So these are some of the things. Now electric vehicles are coming up. Yes, we have our own problems. The vehicles are all lined up on the sides of the road. Up till now, we just got 23 charging stations, and out of them, 10 are in the private hotels in the state. In next 3 months, I've been given to understand that there would be some 100 odd charging stations in the petrol pumps and around 200 in the private hotels. So these are difficulty areas. Now, just 1 minute, please. I'll put an end to it by saying, I have not been able to complete what I wanted to speak, but I'll just put an end to it by saying that yes, everyone wants to have that perfect picture with the nature, with perfect photographs, but one has to remember that you're actually required to give back to the nature, not something else, but your only memories. Don't leave anything else behind in the nature. Take from nature, but don't leave anything else behind except for your memories. You are required to leave the nature in a better way than you found it. And harnessing ecotourism has to be in a very holistic manner. You need to have regulatory framework. You need to have law enforcing agencies. All the places in the world which you find today in a very better, Switzerland is very beautiful. We find it beautiful not because of its legal framework and strict enforcement. So to have a very holistic approach, we need to have regulatory framework, we need to have legal framework, we need to involve the communities, bottoms-up approach, their participation in everything, and also their fair share in the economics, and with an eye to preserve cultural, ecological, and social heritage. Thank you so much. Thank you, Carol. You have a very wonderful example of ecotourism, these backwaters of Kerala, where the locals work in harmony with nature and the enforcement agencies work in harmony with local population. Thank you so much. Thank you.
Thank you, Honorable Justice, for sharing the experience from your own state, and let us promise that we give back to the nature the best and not any disruptive things. May I invite Mr. Jadindra J. Chima, who is fondly known as Jajima, Advocate of Supreme Court of India, to address the gathering.
Please, I have 3 minutes and I have only 3 short notes. So I'll be very, very brief. Honorable Justice C.T. Ravi Kumar, Justice Manoj Mishra, dignitaries on and off the dais, I'll be very, very brief. I will touch upon all the 3 subjects. I've had the benefit of listening to speakers for a day and a half now on sustainability, AI, and transportation. So I have some 7 statements to make. First of all, I'm in a sustainability conference and I'm making this statement that fossil fuels are not going away. the incremental increase in requirement of energy is not going to let us go of the fossil fuels. The tipping point is far, far away in terms of our production of green energy. So I think that's my point number one. I'm glad the justice from Himachal Pradesh raised EV as a possible transport. I have a contrarian view on this. EV is not a solution for us. How do you produce energy that drives that EV is important to know. If you are not, if it's being produced from hydrocarbons, then that EV is really not nothing, next to nothing. So I think very, very important, EV is not a long-term solution. I think there are other solutions which I'm going to suggest are the solutions for us. I think my learned professor from Raipur had raised AI as India spending $6 billion on creating the AI infrastructure. I just want to share with you what are these data centers which are going to drive these AIs, what are they going to be consuming over the next 1 decade. One example I have for all of you is that in the United States, from the year 2024 to 2030, which is 6 years from now, it will need requirement of $1 trillion of energy requirement to drive these AIs. So also, how do you produce that energy, incremental increase in energy? Is it coming from your fossil fuels or is it green fuel? Is how our sustainability debate and development and sustainability is going to play hand in hand. I think the gentleman here had raised yesterday something on the transport sector. I think that's not the big culprit, as you know. I think how we produce energy through coal and through other means is, I think, the real culprit. Historically now, and I think we must know this, the global south, particularly South Asia, contributes only 4%, 4% to the total carbon emissions historically. You know, we are badgered all the time, but we contribute only 4% of the global greenhouse emissions globally, 4%. And imagine India's part of South Asia. So what are the alternatives? I think we are already on the path. I think government is doing enough in creating natural gas space. We have LNG ports, 4 on the eastern coast, 4 on the western coast of coastline of India. I think there is a lot of R&D, and I think Kerala state is doing a lot of work in green hydrogen space. I work very closely with some of them from the state, so I know that very, very progressive work in green hydrogen is being done. Biofuels, nuclear is an alternative. So it's, remember, the basic fundamental. What do you input in a machine process is what we have to worry about, and what emissions come out of it is what we have to worry about. If we have plugged these two things as to what we are going to induce and what are we going to emit, I think our sustainability debate would reach a certain conclusion. I think I'll be very, very brief. 2 small points, ma'am, Lisa. Just 2. Yeah, sure. I think there are, in the sustainability debate, I think climate change debate, there is a big issue. One issue is the trans-boundary pollution that happens. So, for example, if India is doing and meeting its NDCs worldwide, is my neighbor doing enough because the air is common? So I think there's an issue there which needs to be addressed. Yesterday, the polluters pay principle was raised, and I think somebody had raised the precautionary principle as well. I think the jurisprudence in the West now is looking more and more on duty of care. Duty of care for corporations, duty of care for governments, duty of care for, I would say, individuals, because I think it all starts with an individual duty of care. That's very, very important. We know that there is also going to be a disbalance because certain parts of the world are achieving their net zero faster than us. So we're already seeing the signs of the future disputes, which is the CBAMs, the carbon border adjustment mechanism which Europe wants to impose on the rest of the world. And you know who is making the loudest noise in that space? Japan, one of the most advanced countries, because their vehicles will not be able to enter Europe just because CBAM is there. Okay. So I think these are few pointers that I wanted to share, gathering whatever I had shared with, sort of listened to over the last 2 days. Thank you very much for the opportunity. Attorney General, thank you very much for inviting me. Thank you.
Thank you, sir, for touching upon and emphasizing on the duty of care notion and the alternatives to reduce carbon footprints. Now, it's my privilege to invite Professor Dr. Indrajit Dubey, Vice Chancellor, National University, Meghalaya, Shillong, who was my proud professor in Pune University. Welcome, sir.
Good afternoon. And I was watching in my watch that how much Lisa is giving the time. Lisa is my student, so I can take her name. And I saw that those he was pointing out 3 minutes, but she was actually giving 5 minutes. So I'll just seek that particular permission to speak 5 minutes. Honorable Lordship, my dear colleagues from the profession, academic, industry, and it was so nice, enriching to hear all of you. See, being a professor, the discussion is you stand on where the gap is, and that's what we understand in academic, the role of a discussion. And that's what I was figuring out in this talk itself. So there is a 3 things which has been talked about. One is sustainable tourism, then it's a transportation, and third one is a policy making throughout this particular discussion. Now, I thought to have a 2 story, so I can make my, points within this particular story itself. I was heading the law and policy domain of Sea Ganga. If you know about this particular thing, it's a Ganga River Basin Management Project which was given to 7 IIT, and I was from IIT Kharagpur. I was a professor at IIT Kharagpur before I taken over this. And one point of time we have to talk about the Arth Ganga. Arth Ganga is how you can make the tourism sustainable within the Ganga River Basin. And I believe the Ganga River Basin cover actually 2/3 of India, the entire basin. Even Madam was talking about the mountain, rivers and hill and all this thing. So what we thought that the best possible thing is to do data-driven decision making. And we brought a concept which still is in working stage, not as put into the work. This is called decision support system. That means whenever you want to take any particular decision on any of the aspect, because I believe all of us too understood that there is a huge level of interface of the technology into this ecotourism, what you are talking about, and there is a convergence of different technology too. And rather, there is a 2 type of technology in many use. One is in the physical sphere, another is into the soft sphere or into the data-driven mode. And when we talk about the convergence, we basically talk mostly on the data-driven technologies. So that takes me to my next submission. We have talked a lot about the AI or exponential technology. Now the issue is we have also a lot of things speaking together when we are talking about the AI. AI has a lot of understanding. It's a narrow AI, it's a broad AI, it is a generative AI. And the usage of this particular data into these particular AIs are quite different. Energy absorption is quite different. So we have to understand that why do we wanted to bring the policy. So, we have to have a clarity. Other day I was talking with the CEO, in fact a group, talking with the CEO of Millennium Project, and the object is that we have to bring some general note to the UN floor onto that where the countries need to stand relating to the generative AIs. And why it is so? Because we need to have a collaborative approach. Because these particular, I'm done? Okay. So, yeah, I saw this. So, it is, so there should be standardization or collaboration into this particular framework on this particular issue. And the issue is that what you want to standardize, why you wanted to collaborate. Three things has been decided in that particular meeting, and we were working on it. The first one is that what is the quality of the data will come into the technology. Second thing is that will there be a regulation to filter the data when that particular data has been assimilated with the technology. And the third one is that do we require to have a data steward into the different country so that these particular, the convergence can bring into the same level. Thank you so much for giving this particular platform. I believe there is a lot of things to discuss in the future, and I believe that next we can take it over from this itself. Thank you so much once again.
Thank you very much, sir, for your insights. May I invite Professor Dr. A. Kumaralingam, Professor of Law, National Law University, Singapore, and member CLEA South Asia to address the gathering.
Okay, good morning, everyone. I've set my own timer here, so I will kick myself off in 3 minutes' time. I'll just restrict my comments to one key theme, which is transportation ecotourism. And in my view, I think we need to move beyond describing, debating the problem, talking about policies. Policy debates are kind of like pest terminators, they come in to remove the termites, but they always leave a few termites there so they can come back in 4 years' time. We need to move to action, and we need effective implementation. Now, this reminds me of what my son told me that his cricket coach once told him. And he said, when he told the students, do not tell them not to bowl wide. Tell them to bowl on the stumps. And I think that's very good advice. Don't focus on the problems, focus on the solutions. And for me, there are two strategies that I would like to put forth to deal with this problem. One is we need a top-down, evidence-based approach. Ground up is not going to work here. We need to force the issue. The Delhi example of CNG illustrates this well. It can work. Second is I think we need some out-of-the-box thinking. We can't keep doing the same thing, just different ways. Madam Sarika's paper I thought was very interesting when you talked about the streets, right, and how it was redesigned. And this goes back, in fact, there was some of you may know, there was a Dutch engineer, Hans, I forget his name now, Mendeman, who looked at the transportation and road traffic and did something that was completely counterintuitive. At an intersection, he removed the traffic lights, he removed the safety barriers, he put a small roundabout there. He repainted the roads so they looked a little narrower than they actually were. What that did was it made all the drivers a bit more cautious because there was no guidance. Nobody was telling them, slow down here, bridge is there, cow is coming. They had to look out. They naturally slowed down, made the place much, much safer, kind of like that story you gave about that street. So that's the kind of things that I think that we need to be looking at, to be creative, to look at things in very different ways, to come at it from an out-of-the-box approach. And finally, also a point that was made, we do need carrots and sticks, right? It's not just the threats, but also the intense incentives. So the example about the Udaipur snow leopards, I thought that was fascinating. It was a wonderful way of turning it around. In the booklet, there was a little statement there that said that we must align transportation law with ecotourism practices. But we can invert that, and we can try and develop ecotourism laws that will drive transportation practices. Thank you.
Thank you very much, sir. Thanks to all speakers and discussants once again. And with the kind permission of the chair, we will take up one observation or maximum two observation from the research scholars or the students, because they have been asking from yesterday 1 minute observation from any one of our students or PhD scholars as per the advice of the chairman of the organizing committee.
Ma'am, I'm Jyoti, research scholar from the Department of Law, Karyavattam, Kerala University, and doing research on single mothers and their children, respected legal luminaries and dignitaries who are shaping the future of generations in India and the countries, neighboring countries. We have a huge responsibility. When we discuss law, technology, justice, transport, when we talk about all these things, the determinants, I think we need to discuss the determinants which shape the access to law, justice, technology, transport, and tourism. When we live in a caste-based society, when we live in a patriarchal society, when there are class divides, I think it is important that we talk about gender, women's access to justice, the access to justice of LGBTQI community, of tribals, of Dalits, of people, the population who do not speak English, population who's live in rural area. So I think all our discussions and regulations, and when we make legislations also, they should be determined and shaped by the structural constraints and institutional constraints that violate the human rights of many of the population, including women, transgenders, Dalits, tribals, and
Be
rural
brief
population.
and,
Thank
please
you.
conclude.
Thank you.
Thank you for the thank you for that quick intervention. So now we will be distributing the mementos as a token of appreciation. May I invite Learned Attorney General R. Venkatramani sir and Professor Shivakumar sir, President CLEA, to come on to the stage to do the honors of the day. Let us present our memento to as a token of our appreciation to Honorable Chair, Honorable Mr. Justice C.T. Ravikumar, Judge, Supreme Court of India. Thank you, sir. Let us honor Honorable Mr. Justice Manoj Mishra, Judge, Supreme Court of India, who has been the co-chair. Thank you, sir. Let us honor our Honorable Keynote Speaker, Honorable Mr. Justice S. Thurai Raja, Judge, Supreme Court of Sri Lanka, who had come all the way from Sri Lanka. Let us honor Honorable Mr. Justice Somashekharan Sundareshan from High Court of Bombay. Let us honor Honorable Mr. Justice P. Sam Koshi, Judge, High Court of Telangana. Let us honor Honorable Srimati Justice Josna Raval Dua, Judge, Himachal Pradesh High Court. Let us honor Professor Dr. H.J.F. Silva, Vice President CLEA, London, UK, who came from London and who has been always instrumental in all the organizational aspects of CLEA activities. Thanks a lot, sir. Professor Dr. V.C. Vivekanandan, sir. Mr. Mr. Rohan K. George. Mrs. Sarika Pandabhat. Mr. Jadinder J. Chima, Advocate, Supreme Court of India. Professor Dr. Indrajit Dubey, Vice Chancellor, National University, Meghalaya. Professor Dr. A. Kumaralingam, Professor, National University, Singapore. And Secretary, CLEA Asia and Advocate, Supreme Court of India, Dr. Vikram Singh Arya. Venkat, Learned Attorney General and Professor Shivkumar is kind enough to give me also a memento. So I will receive it. You don't give me?
Of course.
You can give like that, sir. No problem, we will fix it. So I will. Take it. Dr. Anida Patil, Secretary, CLEA Asia, Joint Secretary, CLEA Asia. Yes, sir, it's done. Thank you so much, Learned Attorney General and CLEA President. May I invite Dr. Anida Patil, Associate Professor of Law, Ramaya College of Law, Bangalore, and Joint Secretary, CLEA Asia, to propose the vote of thanks.
Greetings of the day, esteemed Honorable Justice, distinguished speakers, guests, and participants. As we conclude this enlightening session, technical session of 3 on collaborative approaches and best practices in ecotourism and transportation law, I stand before you, Dr. Anita Patil, mainly expressing our heartfelt gratitude to all who have made this session a resounding success. Thank you all. A special word of gratitude to our chair and co-chair, Honorable Mr. Justice C.T. Ravi Kumar and Justice Manoj Mishra, sir. Thank you, sir. Our keynote speaker, Honorable Mr. Justice S. Thurai Raju, sir, for setting out the tune for a discussion with their enlightening session. Thank you so much, sir. We are also deeply honored by the presence and insights of our eminent speakers, Honorable Justice Somsekhar, High Court of Mumbai, Professor H.L. Silva, sir, Vice President of CLEA, London, the Professor Dr. V.C. Vivekanand, sir, the Vice Chancellor of HNLU and Executive Member of CLEA. Thank you, sir. We would also like to express our gratitude to Mr. Rohan George, partner at Samvad Partners. Thank you, sir, for enlightening session. Srimati Sarika Pandabhat, founder and trustee of Ragiri Foundation. Your all expertise and perspectives have mainly greatly enhanced our understanding of this critical issue at hand. Thank you all. I would also like to express my gratitude and sincere appreciation towards our distinguished discussants, Honorable Mr. Justice Sam, who is the Judge of High Court of Telangana, Honorable Mr. Justice Josna, Judge Himachal Pradesh High Court, Mr. Jatendra, Advocate Supreme Court of India, Professor Dr. Indrajit Dubey, sir, Vice Chancellor of HNLU Meghalaya, Shillong, and also Dr. Kumaralingam, Professor of Law, National Law University of Singapore, member CLEA, for their valuable contribution towards our session. Our special regards to our moderator, Professor Dr. Lisa Lucchese, for her skillful steering the conversation, as well as all our rapporteurs, Dr. Dayana, Dr. Binu Mole, as well as Ms. Vasudha, for their diligent work in capturing the essence of all our deliberations during the session. Thank you all. As we depart, let us carry forward the collaborative spirit and innovative ideas shared here today, working towards a more sustainable and future in ecosystem as well as the transportation law. I thank you one and all for your contribution and participation for making this session a grand success. Yes, sir.
I'll be failing in as chair if I do not make an exhortation. One thing, let the eco-tourism flourish, but let not the ecosystem perish.
Thank you, sir. Thank you very much. I'm the timekeeper for the next session, so I'll request everyone to go down and the next session to start. We have a session chaired by Honorable Justice Prashant Mishra, sir.
Politely kicking us off, right?
Thank you, I'm sorry. And I can assure you, the tea we will have to do in portions. We can't all go out together for tea. So please make yourself comfortable. Go for tea, maybe a couple of people at a time. I'll request the next session, Chair and Co-Chair, Honorable Justice Prashant Kumar Mishra Sahab, Honorable Justice Vinod Chandran Sahab, Chief Justice, High Court of Patna, Honorable Mr. Justice Anil Kumar Sinha Sahab, former Judge, Supreme Court of Nepal. Then our speakers for the next session, our gracious host, Justice Mushtaq sir, Justice Sundar sir, Honorable Justice Anita ma'am, Justice Govindraj sahab, Mr. Abhivardhan, Justice Saurabh Banerjee sahab, the Attorney General for Fiji, Mr. Leoing, Mr. Bakshi, Advocate Supreme Court, Mr. Rajiv Amar Surya, Mr. Akhilesh Suresh, and I will request thank you, sir, my colleague Ayappa Maniji to please join here for the welcome also. And while we are just settling the dais here with the next speakers, I want to tell you a small story also to dissuade you to go for tea. The small story that I heard from my mother, I want to share it today because I feel it's contextual on what our roles should be in the topics that we discuss. Please come back. The small story is that there was a Mahatma passing through, a great Mahatma passing through a small village. And the village elders persuaded Mahatma to stay in the village for the night. And they said, you stay and you bless us. In the morning you do enlightenment for the village. That will bless the village and we will have prosperity and happiness in the village. So Mahatma assured that I can do this exercise. But what I want to do this, what I need for the exercise is I want every house in the village to bring one bowl of milk. And that milk should be brought in a big pot which will be kept in the center of the village. And every house of the village has to bring one bowl of milk and pour in that big pot. And with that milk I will perform the puja which will bring joy and prosperity to the village. Now this exercise has to be done before sunrise. So the richest house of the village, most affluent house of the village, they thought to themselves, everyone else will be bringing milk, let's put a bowl of water in that. How will it, nobody will get to know because when everyone is bringing milk, one bowl of water does not matter. Well, the morning came and in the morning when the pot was opened in front of the whole village for carrying out that puja, that big earthen pot had not a drop of milk in it. It had only water because every house of the village felt, my bowl can have water, everyone else is bringing milk, it will make no difference. I think it is time for us to realize that we all need to bring the milk for the puja or the enlightenment that is required, and none of us can shrug our hands off. Thank you very much, sir. May I request you to please have a seat and request Ayappa Maniji to please welcome everyone.
I welcome you all to this technical sessions, which is an essential part of our broader discussions focusing on the interplay between law and technology and justice in enhancing the sustainable transportation, tourism, and empowering justice delivery system through technology. The sessions is divided into two critical streams. The stream A is case management and judicial decision making, enhancing the efficiency through technology and global practices. Stream B, advancing judicial systems, comparative insights and technology and judicial best practices, will devolve into how we can leverage technology into strengthen the legal framework and enhance the efficiency and access of judicial delivery system. We are privileged to have with us an outstanding panel of speakers who will guide us through their thought-provoking insights that will not only inform us but also inspire us to strive to create a more sustainable and just future. I extend my warm welcome to our chair for the sessions, Honorable Justice Prashant Kumar Mishra, Judge, Supreme Court of India, whose vast experience and judicial wisdom will be invaluable in steering our discussions. I am equally honored to welcome our co-chair, Honorable Mr. Justice Muhammad Mustaq, Acting Chief Justice of High Court of Kerala, whose expertise in the legal domain will further enrich our legal deliberations. We are also delighted to have with us Honorable Justice Anil Kumar Singha, former Judge, Supreme Court of Nepal, as our keynote speaker, and also delighted to have with us Honorable Justice M. Sundar, Judge, High Court of Madras, and Honorable Justice Dr. Justice Anita Sumant, Judge, High Court of Madras, Honorable Justice Suraj Govindaraj, High Court of Karnataka, Honorable Mr. Justice Suraj Banerjee, Judge, High Court of Delhi, and all other speakers. I am also happy to share my dais with my mentor, dynamic moderator, Madam Aishwarya Bhatti, learned Additional Solicitor General, Supreme Court of India. We are honored to have industry experts and technical experts, Mr. Advocate Habivardhan, Mr. Graham Wedling, Honorable Attorney General of Fiji, and Pradeep K. Bakshi, and Supreme Court of India, Mr. Rajiv Advocate, and Raj Amrasurya, Advocate, Supreme Court of Sri Lanka, Mr. Akhil Suresh, BP Senior Partner, Bharti's Legal. They will discuss about the topic. I am grateful to Payal Ajimra, doctoral scholar, for delivering a vote of thanks, and the reputed Advocate Devand and Dr. Kavita, Dr. Amli, the technical persons will be there with us to assist us. Let us approach these sessions with an open mind and collaborative spirit and ready to engage with the ideas and perspectives present. Thank you for your participation. I look forward to the valuable insights and ideas that will emerge from this section. Jai Hind. Thank you.
Thank you, Ayappa Maniji. We welcome our chair and co-chair both. I have strict timekeeping instructions from everyone. I am only a timekeeper. I am not the time, so I can't extend it. I will pass you a slip. Please conclude. And I promise you that I won't make any comments about the speech, so to keep it short. May I request Honorable Chair, Justice Prashant Mishra Sahab, to start the address, please.
Vinod Chandranji, the Honorable Chief Justice of Patna High Court, Justice Mustaq, the Acting Chief Justice of Kerala High Court, my other respected brother judges from different high courts, the distinguished speakers, academicians, and experts in the field, learned Attorney General, Honorable Chief Justice of Seychelles, Roni Govindan, other brother and sister judges of the dais, dear participants, a warm good afternoon to all of you. We are here in the conference devoted to sustainable transport, tourism, and technological innovations on law and technology. And we have been, since yesterday, through the brainstorming sessions on different topics. And for the present, we are here to deliberate and discuss about enhancing capacity and decision making, policy, law, and justice. Capacity building in decision making is not merely a technical endeavor, it's a fundamental aspect of our responsibility as custodian of justice. The judgments have a trickling effect not only on the lives of the parties directly related to the case, but also on their families and the world at large, impacting the lives of millions of citizens. Thus, it is incumbent upon us to ensure that decisions are informed, just, and equitable. In the context of judiciary, capacity building involves continuous learning, staying abreast of legal developments, and understanding the socio-economic context in which the law operates. The interplay between policy, law, and justice is complex and multifaceted. As judges, we often find ourselves at the intersection of these three domains, where we must balance legal principles with the broader objectives of public policy and the demands of justice. This task is particularly challenging in a diverse and dynamic society like ours, where the law must constantly evolve to address new challenges. Consider, for instance, the growing intersection between technology and the law. As new technologies emerge, they bring with them novel legal issues and require careful consideration and nuanced understanding. But at the same time, such technologies offer us avenues for betterment of the justice delivery system. The question then arises, how do we equip ourselves to make informed decisions in areas where the law is still developing, and how do we ensure that we are making good use of technology for the ends of justice? The answer lies in capacity building, in investing in our knowledge, skills, and understanding to ensure that we can navigate these complexities effectively. Technology plays a pivotal role in enhancing our capacity to make informed decisions. It offers tools that can aid in legal research, case management, and even the delivery of justice. However, technology is not a panacea. While it can enhance efficiency and access to information, it is ultimately our human judgment that must guide the application of the laws. As we embrace technology, we must also be mindful of its limitations and potential biases. We must strive to ensure that technology serves the ends of justice rather than undermining them. It is with this perspective that we, in the courts, use several technological initiatives to aid the judges, lawyers, and litigants traverse the judicial system better. An area in which technology has helped us immensely is case management and judicial decision making. There are various topics on which we can speak of elaborately, but given the time constraint and the timekeeper, it is difficult to elaborately discuss all the topics, but I will just speak about the headlines or the captions which deals with this technology and law. First is the case management and judicial decision making, enhancing efficiency through technology and global practices. A complex and interconnected world presents us with new challenges and opportunities. The same is true for court management as well, which is a dynamic and constantly evolving field. One way in which our court management is evolving is through the use of technology. Court management refers to the set of procedures and actions taken by courts to control the flow of cases, monitor their progress at each stage of the life cycle, and ensure efficiency in the system by utilizing resources optimally for their effective and speedy disposal. Then comes the technology as a catalyst for efficient case management. The process of digitization of judicial administration in India, which commenced in 2004, with a vision to enhance judicial productivity and to make justice delivery system more accessible, affordable, and accountable. The shift from manual to digital data system has gained significant traction in recent years as the use of technology has proved to be a factor in the improved efficiency of the court system by allowing for faster and more accurate data management. The e-courts project is also a part of the endeavor to manage our judicial system, case management, and data management. We have developed case management software at all levels, all court levels, whether it be the trial courts and up to the apex court. The case information system, which is developed and is available for district judiciary and high court exclusively, is created under the guidance of the E-Committee Supreme Court of India through the software team at the National Informatics Center. The whole idea of CIS, to put it in a nutshell, is that the litigant should be able to view the daily status of his case, to view the orders of the case, hearing, and the progress of the case on particular date, on timeline from any part of the world. You can have access to the National Judicial Data Grid of the country, managed to CIS, from anywhere in the world. And any litigant sitting at any other part of the world can have access to the information about his case. Then we have developed the electronic filing system, particularly in the Supreme Court and High Courts, but now it has gone down to the district court level also. The courts are encouraging delivery of e-summons through mails and even through WhatsApps also. Then there is one e-court mobile service app which has been developed, which enables a litigant to search the case to obtain the information by scanning a QR code through a mobile application. Now comes the topic of use of AI in case management and judicial decision making. That will be deliberated by learned speakers. This is also case management. And I will skip about the international practices, but now comes the advancing judicial systems, comparative insights on technology and judicial best practices. I hope the eminent speakers will elaborate on this topic and enlighten the audience for the benefit of the whole legal system and public at large. And I thank you for the organizers, particularly Learned Attorney General, for having invited all the judges, all the legal luminaries in this function, in this conference, and that will surely benefit the all stakeholders at large. Thank you so much.
Thank you, Honorable Chair. I had strict mandate from the chair itself to be the strict timekeeper. And now I invite the co-chair, Honorable Justice Vinod Chandran Saab, Chief Justice, High Court of Patna, to please share his reflections.
Respected Chair, Justice Prashant Kumar Mishra, the Honorable Judge of the Supreme Court of India, Acting Chief Justice of Kerala, Justice Mustak, eminent panelists, dignitaries in the audience, my brothers and sisters, legal fraternity, industry, and students. See, when we talk about interspersing technology with judicial systems, we cannot but remember the pandemic period. COVID-19, out of sheer necessity, drove us to accept and depend on the digital platforms. The electronic court management systems were introduced first in India in the year 2005. More than the progress we achieved in the 1.5 decades after that, we have made vast strides in the past 5 years. But have we slackened? after the world opened up is the biggest question we all have to address. Now, in considering the problems that arise, I have flagged 3. There may be many others also. The first one is the technological and infrastructural barriers. In Bihar, in the recently concluded Lok Adalat organized by the Honorable Supreme Court, we had about 300 cases targeted. We had to take the administration's help to get the litigants to centers which had e-facilities. Mind you, those were all people who had access to the Honorable Supreme Court. They filed their cases there, but they did not have access to e-facilities. Augmentation of infrastructure has to go hand in hand with public awareness. Building of public awareness is also very important in integrating technology with judicial systems. The second problem I perceive is training and adaptation. Training modules are in place, but for adaptation, no amount of training would suffice. It has to come from within. As judges, lawyers, and other supporting staff, we are still in the mold of physical hearing. We don't go for virtual hearing. I remember the pandemic period when myself and I think it was Justice Dias, we were sitting in, I was sitting at home because I was a primary contact. He was sitting in his chambers, supporting staff in the court, lawyers arguing through the digital platform. Without any physical interface, we went ahead. Now, we prefer physical hearings. The lawyers prefer that, the judges too. We have to definitely get out of the mold. The third problem is data security and privacy. We know that now privacy has more ramifications with the right to be forgotten. But I am sure that these barriers would be broken and the frontiers would be extended to hitherto unknown. The new frontier which all of us have been talking about is artificial intelligence. There is a lot of interest generated, and equally the naysayers voice a lot of apprehensions. In the US, the courts are puzzled with lawsuits on music copyright. We also had our own verdict of the Bombay High Court in Arijit Singh's case. The accusation is that imitations on AI is pure and simple stealing and sabotaging creativity. One of the musicologists is lamented that music is not just a stream of words. It has a rhythm and a pitch and harmonic context. I believe that judgments also have a rhythm and pitch, and a harmonic context is provided by the facts in the individual case, which is difficult to be cloned. So as far as judicial decisions are concerned, I would say AI is a big no-no for the present. Now, we have to accept that the mood is upbeat and there is a lot of, the future looks very bright. It has been famously said that pessimism is full of wisdom but sterile wisdom. Optimism is full of madness but creative madness. Our job would be to blend creativity with wisdom. And in breaching barriers, there has to be a mad streak, but tempered with the wisdom of experience. In embracing technology, we should create equitable solutions without ignoring the ethical considerations. I would say that fair procedure is the cornerstone of any effective justice delivery system. The benchmark standard will be determined by transparency, efficiency, and consistency. Transparency in procedures, efficiency in disposal, and consistency in execution. I think I have not taken my 8 minutes, and I hope the moderator would not ask me to stand here for the 8 minutes. Thank you.
Thank you so much, sir. I'm so grateful. May I now request our friendly nation judge, Honorable Justice Anil Kumar Sinha Sahab, former judge, Supreme Court of Nepal, to please share his reflections.
Thank you. Your Lordship, Chair and Co-Chair of this session, honorable colleagues, esteemed guests, ladies and gentlemen, on and off the dais. 34 years of my persuasion to the bench as lawyer was to persuade the judges to take appropriate judgments. Then came the 7 years of judgeship, and the lawyers persuaded me to take proper decisions. And here I am when I got the invitation from respected AG and Professor Shiv Kumar. Then I thought of writing out a small note, and they said, did a proper job? Have I missed out many things when I made the judgments? And there I had some points in my mind which most of that has already been addressed by the chair and the co-chair. But still I have got something in black and white here in front of me. I'll just go through it and try to be on time. The intricate nexus of policy, law, and justice, woven by fine thread, constitutes the foundation of good governance and demands systematic, synchronized, and coordinated efforts. Decision-making at its core is a cognitive process that involves selecting a course of action from a set of alternatives by human brain. And that's, I'm focusing on the human brain because even AI doesn't work in isolation. It is the creation of the human brain itself. It is influenced by a myriad of factors, including individual knowledge, belief, values, skill, adaptability, and experiences, as well as external pressures and constraints that we sometimes get when we are in the bench. In the realm of public policy, law, and justice, these factors are magnified, with decisions often impacting the lives of countless individuals seeking justice. Some even await a conclusion that court reaches so that they can follow the path for future to avoid disputes leading to legal process. The capacity to make sound decisions is essential for effective governance. It underpins the development and implementation of policies that address societal changes and creation of the laws that promote justice and equity, and the adjudication of disputes in a fair, impartial, and effective manner. However, this capacity is not inherited. It must be cultivated, nurtured, that needs commitment, adaptability to situations, dedication, and thoughts beyond the boxes. One of the critical elements in enhancing decision-making capacity is the development and implementation of well-designed policies. They set out goals, objectives, and strategies for achieving desired outcomes. Effective policies are evidence-based, inclusive and transparent. They are informed by rigorous analytical, engage a wide range of stakeholders, and are subject to policy scrutiny. To enhance decision-making capacity through policy, we must invest in research and develop data collection that needs sufficient budget for expenditures with flexibility with the judiciary to prioritize. We need to develop robust technological system for monitoring and evaluating policy outcomes. In this age of borderless and boundless developments of artificial intelligence, we must also foster a culture of learning and adaptation, allowing for flexibility for course corrections whenever necessary. Furthermore, it is imperative to strengthen the capacity and accountability of public institutions to analyze complex issues and develop innovative solutions in coordination. Law as a system of rules and regulations plays a crucial role in shaping decision-making. It provides a framework for resolving disputes, protecting rights, and maintaining orders. More clear the law is, more efficient and effective the decisions will be. Hence, to enhance the decision-making capacity through law, we must strive for clarity, consistency, techno-friendly, and accessibility. Laws should be drafted in plain language, and their implementation should be clearly communicated to the public. One of the critical issues is enactment of the conflicting laws, of which the draft originate from the interest group or ministries of the various governments. Delays in administration of justice erode public confidence and undermine the rule of law. Investing in technology, human resources, data collection, and information dissemination that can help streamline legal process and improve access to justice and achieve the objectives. In this capacity, enhancement of decision-making, technology has emerged as a powerful tool across the sectors. Data analysis, AI, and machine learning can provide valuable insights into complex problems, enabling policymakers to make informed decisions based on evidence. Furthermore, digital platforms can facilitate public participations and engagement, ensuring that policies are responsive to the needs of the citizen and not ornamental only. However, it is crucial to use technology ethically, responsibly, addressing the concerns about privacy, security, and equity. An independent judiciary, as the guardian of the law, plays a pivotal role in this. Judges are tasked with interpreting and applying the law to specific cases to enhance their capacity. There is no alternative to adequate training and technological support. The belief that only the judges can teach and train judges has to be shared away. They must be equipped with the knowledge and skill necessary to address complex legal issues and make informed decisions with support of better knowledgeable and skilled staffs. Technology is revolutionizing the process and pace of judiciary justice delivery, from artificial intelligence aiding in legal research and predictive analytics to e-filing and online dispute resolution platforms. Digital tools are enhancing efficiency and accessibility. However, it is imperative to employ technology judiciously, using human brain, ensuring that it complements human judgments rather than supplementing it. Moreover, there is a pressing need to bridge the digital divide to prevent further acceleration of existing inequalities in access of justice. In conclusion, enhancing capacity in decision-making is a complex and multi-faced challenge. It requires a holistic approach that addresses the interconnectedness of policy, law, and justice. By investing in research, data, and technology, by strengthening institutions, and by promoting equity and inclusiveness, we can build a more effective and just society. It is imperative that we work together to create a culture of evidence-based and reasoned decision-making, where data and analysis inform policy choices, where laws are clear and accessible, and where justice is administered fairly and impartially. By doing this, we can build a stronger, more resilient, and more equitable future for all of us. Thank you for active listening.
Thank you very much, sir. Since we have advantage of a couple of minutes, and Honorable Chair was of the view that we should be solution-oriented, and I know the captain of our ship is making notes for the Kumarakom declaration that we are thinking. May I suggest, with the permission of the chair and a couple of extra minutes that we got from the co-chair, that we have, in addition to a declaration, something of a reflection. Each one of us has some position in the society. We are in places, we are 7 countries here, so many high courts. Maybe we could make it more fashionable to go plastic free, make choices that in each one of our lives, we have earth as a focus. Switch off the lights, use less of the resources, and go make choices which make us plastic free. Just leaving this thought with you, sir. May I now start with the speakers. You will all have 8 minutes each, and I want to start with Honorable Justice Suraj Govindarajan, sir, Judge, High Court of Karnataka. 8 minutes are yours, sir.
This is Prashant Kumar Mishra, the chair. This is Vinod Chandran, the vice chair. This is Mohammad Mushtaq, acting Chief Justice of Kerala. My co-panelists, discussants, friends from other high courts, and the experts in the field. The topic for this session is case management and judicial decision making, enhancing efficiency through technology and global practices. Advancing Judicial Systems, Comparative Insights on Technology and Judicial Best Practices. So when I saw this topic, I was wondering, what does it have to do with sustainability? And this seminar is more focused on environment, sustainability. How does this fit in? So why would somebody think of this kind of a topic? Then the other thought that struck me was Commonwealth legal education. Leave out the legal education, let's look at the Commonwealth. We are speaking of the Commonwealth, we are speaking of our environment, we are speaking of the wealth of all of us, and how do we safeguard it? Then the thought was as to what do the judicial proceedings or the actions of the government have to do with the environment? Everything in terms of policy, rules and regulations, but what is the immediate effect? What does the executive have to do with sustainability? What does the judiciary have to do with sustainability? Then the first thought that comes into mind is paper. The amount of paper that we use in the judiciary, in the executive, is mind-boggling. The estimation is the number one sector which uses paper is education, obviously. Students have to have paper and book, and they have to have their textbooks, they have to have their library, etc., which is now digitized. The second most consumer of paper is the judicial system. Now, if you add the executive to it, because much of the litigation starts from the executive and comes to the judiciary. This application is filed, not considered, mandamus. These applications are also filed by paper. The work by the executive is done on paper. So what is the solution that we could look at? Less paper, paperless? Can we have the executive functioning to be done electronically in terms of all the applications which are filed by a citizen of the country to be done electronically so that there is no paper wastage? Why so? How much paper comes from one tree? It was interesting for me when I looked at it. It says it's estimated that a standard pine tree, which is normally used for paper, with 45 feet of usable trunk, 45 feet from here to that end, and a diameter of 8 inches will produce around 10,000 sheets of paper. 10,000 sheets of paper is one tree. 500 sheets, which one ream we just use by the way, and we finish it in a day that we use for our orders, judgments, etc., each of us, uses 5% of a tree. Now we are looking at digitizing and scanning the records of the judiciary. The phase 3 project, over which we are spending 3,200 crore Indian rupees for the purpose of digitizing, proposes to digitize around 3,600 crore pages. Now if I extrapolate the number of trees for that, it comes to 1 crore 44 lakh trees. Sorry, I haven't worked it out in millions for some of you, but we are comfortable more with lakhs and crores, so 1 crore 44 lakh trees are what is in our repository in terms of files. How much is going to come into our repository in the future? Now this 1 crore 44 lakh trees is only for what we have in the judiciary. Imagine the Attorney General's office, Solicitor General's office, the Advocate General's office, the litigants. You multiply, each file is multiplied into 4. So if you have 1 crore 44 lakh trees, you multiply it by 4, that makes it around 5 crore trees, 6 crore trees is what is lying in the paperwork of the judiciary or the dispute resolution system. Now imagine the next one of the litigant having a file, certified copies which are made, which are printed out and taken out and given to various other people. How much of the impact that we have on the environment in terms of cutting down trees for our judicial dispute resolution system could be saved? We have introduced e-filing. Isn't it time, doesn't it become an incentive more so in this kind of a setting, in this kind of a conference, that we promote e-filing, not only for the purpose of ease of use, but as our contribution to the environment? preservation of environment, would that not be a better thing to do? Would it not be a good thing to do? Would it not be a right thing to do? Forget our ease of use. As a contributor to the environment, to the better maintenance and preservation of the common wealth that we have, could we do that? Secondly, transport. I was wondering what would transport do with the judicial system? Then I was wondering everything. There are people who come to court day to day, every day, morning, and go back in the evening, or some of them go back in the afternoon and come back in the late afternoon, depending on what their case is. There are litigants traveling to court. There are court staff traveling to court. There are so many people who are traveling to court. Can we look at minimizing that travel? The solution is already there, as many of the speakers have spoken about, virtual hearing, hybrid hearing. Can we encourage that to reduce the transport to and from court? Would that be a better way of looking at virtual hearing and hybrid hearing? Would it reduce? There are counsels who are traveling from state to state, from city to city. Imagine the airfare, imagine the air travel, imagine the ground travel, stay, etc. Could we look at that as one of the ways of impacting the environment from the dispute resolution perspective? One of the very interesting thing which came about was, okay, EV vehicles are there, but you need power, and the power, fossil fuel is not going to go away, we have to use this. Could we look at making all courts self-sufficient in terms of solar or wind power? Could we put across a system, the Attorney General is here, his patron, could the state look at making every court complex self-sufficient in terms of solar or wind, whichever is suitable, depending on the location, so that we are not dependent on the grid power? Firstly, the courts become self-sufficient, the executive offices become self-sufficient, then next progression is obviously going to be to the executive offices. The last aspect was tourism. Could you play that video, please?
Imagine a world where the boundaries of tourism are redefined. Welcome to the era of virtual tourism, the latest frontier in the tourism industry. Why this shift? Firstly, it's about accessibility. Now, the pyramids of Giza or the Northern Lights are just a click away. Everyone can experience these wonders without leaving their homes. Secondly, it's about sustainability, offering a green alternative to traditional travel. And let's not forget the diverse experiences on offer, from historical reenactments to futuristic space tours. But what about the economy? Virtual tourism opens up new revenue streams, from virtual tours to digital souvenirs. It creates jobs for virtual tour guides and digital content creators. It fosters partnerships and collaborations between traditional travel agencies and tech firms. Industry insights show that interest in virtual travel experiences is high. The global virtual events market, including virtual tourism, is expected to reach over $400 billion by 2027.
You could stop that.
At BizTech, we're harnessing the power.
Is this the new paradigm of travel? We are speaking of ecotourism. Could we encourage virtual tourism? If the state were to create virtual tourism places, you have Oculus, you have got Apple Vision now, the equipment is there. Maybe Apple Vision is a little more expensive today, but going forward it is going to become cheap. Is it possible? A lot of people can't afford to travel, a lot of people want to travel. Could they sit at home and travel to those destinations, have a look and feel, have an immersive, interactive experience on things without actually going to that place? It could facilitate one, is a lot of people who can't come will be able to come. A lot of people, the footsteps, leaving footsteps or living thoughts or living memories, living or taking memories or doing whatever in the place could probably get avoided. And if this is done at the governmental level, there could be a percentage of that sale of that particular, it's not going to be free. You could charge for it. If you charge for it and out of that probably $10 or $20 of a visit, could 20% go to the municipality of that particular place? Could that be used to preserve the environment, to better the situation in that particular place? There could be a lot of other ideas on it, but the timekeeper to the nation is not allowing me to speak, so when in court, we'll take care. Okay, thanks a lot.
I apologize profusely, sir. Like I said, I have to keep the time. It's the mandate of the chair from the Supreme Court. So may I now request Honorable Dr. Justice Anita Sumant, ma'am, Judge, High Court of Madras, to share her views, please.
Honorable Chair and Co-Chair, distinguished invitees both on and off the days, ladies and gentlemen, good afternoon. I thought with a star-studded room like this, it would be safer to go with a generic greeting rather than take names. In this session, we discuss the interplay between two very critical areas of the judicial institution. Simply put, they are technology and judicial delivery. Now, since the time assigned is limited, I have crystallized 4 points that I will make and prefaced with a very brief introduction. When I was called to the bench, I was naive enough to think that it was all about the law. Reading wide and broad about legal issues, different subjects, mulling over the march of the law, the fine art of drafting judgments, the conundrum between writing an order and doing what's right. That was what I believe the assignment was all about. Now, a few months into it, reality dawned, and I realized that the role of a judge is doing a perfect balancing act between being a jurist, a scholar, a mediator, an administrator, a manager, a good Samaritan, and many other roles. And it is in finding this right balance that one has to hone other skills as well. So today, when we talk about capacity building, it's not just quantitative, but qualitative, with the ability to improve processes being the focus. The ability to think wide, to think laterally, and to think at a macro level. My first point would touch briefly on the most significant technological advances that we've had in Indian courts. The previous speakers, particularly Chief Justice Vinod Chandran, took us through some of those developments. While pilot projects for virtual courts are not anything new, we've had them for the last more than 15 years, it is the silver lining in the COVID pandemic that propelled us to the world of virtual courts. And today we find that virtual courts are the norm in many courtrooms, though there is much scope for improvement there. The benefits are inclusivity, economy of scale, and far greater productivity in far less time. Now, virtual courts have been implemented for specific issues such as traffic challan offenses, and we have the central motor vehicle traffic rules that have been implemented that provide for a platform called EDAR, which brings on board all stakeholders in the area of motor accident compensation. In fact, we have implemented this as a nodal project in one of the districts in Tamil Nadu called Chengalpet. And in Chengalpet, we have brought on board about 7 of the stakeholders. This will be of particular interest to one of the speakers in the earlier session, Mrs. Sarika Bhatt, who shared with you the model of how to contain road accidents in Haryana. In fact, the Indian Institute of Technology, Madras, has, this is a project funded by the Ministry of Road Transport. They have what is called a Center for Road Excellence. Center of Excellence for Road Safety, a Center of Excellence for Road Safety, where they do a lot of collaborative work to see how best road accidents could be contained, and they claim to have achieved a great deal of success in arriving at data collation and in measures that they have rolled out to ensure safety on roads. Now, with this project, which is to bring on board the stakeholders, which is the highways, the police, the victims, the insurance agencies, and all other stakeholders, we believe that the payment of compensation to a road accident victim would become seamless. And this, to my mind, is one of the better examples of how to marry justice delivery with sustainability, because you're doing away with all the intermediaries in terms of court hearings, etc. You're using technology in a robust manner to bring on board stakeholders who could then work in a collaborative fashion to deliver justice to an accident victim. Now, the second point, the success of this adaptation to technology, and this is the elephant in the room, is it is dependent on the unstinting participation of stakeholders. We have to be candid that there is a marked reluctance among those in the judicial institutions to make it their own, make technology their own, and to use it in as many ways as are possible. Now, it has been said that the mind is a powerful focus. It can make the worst of the best or the best of the worst. And therefore, it is up to us as a community, or at least as a community within the larger community with the required proclivity, to herald and fuel this transformation. I noticed from some research that I was doing for this session that the United Nations Development Project, the UNDP, has brought out what they call a judicial integrity toolkit. When we say judicial integrity, it is only in the context of use of technology. And I would urge, for paucity of time, I'm not able to share those bullet points with you, but do visit this. It's called the Judicial Integrity Toolkit in the context of technology, which informs the judicial institutions how best we can implement measures to bring home facets of technology into our own daily work, whether it is judicial work or administrative work. That would take me to my third point, which is one very close to my heart. This relates to professionalizing our institution. And what do I mean by that? To the extent possible, I believe that some portion of the work that judges do can be farmed out or usefully delegated to those who have the skills to perform that role. There are certain arenas of the judicial institution, for instance, training of judges or selection of those who are in the district judiciary, that we should zealously guard. We have to keep that within our own control. But there are other areas, for instance, technology itself, purchase of software, devising of technology that would be best used or assimilated in judicial institutions. I believe there are professionals whose assistance we should take in order to optimize the benefits that we get from this. The fourth point, and that's the concluding point, is that in all this discussion about systems, one shouldn't lose sight of the people who populate or inhabit those systems. After all, technology, like procedure, is only a handmaiden of the system itself. And in my view, this is the most critical aspect of a marriage between technology and a traditional judicial management. Business textbooks tell us that there are four pillars of capacity building: operational, management, finance, and personal capability. But to my mind, the greatest asset that we will be building if we do embark on this project of capacity building is that we can dissolve differences and iron out inequalities. The single-minded target is of improving quality, and in doing that, we must find ways to ensure that everybody wins. I'd like to end with a note of caution. Before that, just a word on what the previous speaker, Justice Suraj Govindraj, had shown us an interesting video on virtual tourism. In fact, I had occasion to see a video, which I shared with Justice Bhatti also, on how a Brazilian judge, who's a magistrate in Brazil, she conducts a court on metaverse. Metaverse, or Web 3.0, as you all know, involves virtual reality. So she conducts a case involving traffic challans. But there is some takeaway from it, in that what happens is that the different parties stay where they are, and the judge integrates over metaverse. So there are certain situations, for instance, POCSO offenses, or offenses involving marital rape, or other situations which would be better off if the parties were away from each other, where this would be a useful takeaway. I wanted to just share with you, just 30 seconds, the note of caution that I wanted to end on is that while one machine can do the work of 50 ordinary men, it's been said that no machine can do the work of one extraordinary man or an extraordinary woman. And there was one speech that I heard of a very popular very popular monk from the Ramakrishna order. He said, I wanted to try, what is AI all about? So he asks artificial intelligence, generative AI, which is the in thing today. He says, write me a poem on Swami Vivekananda. So it trots out a poem. And then he says, write me another. And he does this 50 times. And he gets 50 poems on Swami Vivekananda, all in the space of, say, 45 minutes. Perhaps it's not possible for a human being to have that much of capacity. But then the quality of the poems that are written, the authenticity of the content of those poems, they would remain matters that we have to look into, a human being would have to look into and verify. And therein lies the difference between the use to which we put AI in our institutions. Processes, yes. Substantive issues, I would be cautious. The Toronto University has what they call the Future of Law Lab. And our Supreme Court itself has got a Center for Excellence in Law where we are researching these issues. So it's a work in progress. It's been a pleasure speaking to you. Thank you very much for this opportunity.
Thank you very much, ma'am. May I request Honorable Justice Sundar, Judge, High Court of Madras, to please share his views.
Putting the stopwatch. Honorable Justice Prashant Kumar Mishra, Honorable Justice Vinod Chandran, Chair and Co-Chair, all the other dignitaries, ladies and gentlemen, good afternoon and greetings. Normally, the court keeps the time for the solicitor. Today, the solicitor is keeping time. Therefore, I have decided to become a counsel. And I would be playing devil's counsel. The reason why I said I will play devil's counsel is I would be speaking about one part of one limb of one sub-theme of the theme before us. Please see the theme for a moment. The theme, and then there are two sub-themes. And the first sub-theme talks about judicial decision making, enhancing efficiency through technology and global practices. On technology, the most fast evolving facet of technology, AI, is where I'm going to play the devil's counsel. And I'm taking on from where Honorable Chair left at CMH, saying judicial decision making, I will leave it to the speakers. So I pick up the baton from there and make an attempt. Before I make an attempt, I've switched on the stopwatch myself, so I will mind my time. I need to tell you, Dr. Kumaralingam, the last speaker in the previous session, very nicely said, don't bowl wides and you'll have to bowl at the stumps. Well taken, absolutely right. But then you have to mind line and length also. And you attempt in a Yorker, and if it lands 4 inches above where it was intended to, you know what happens. History will tell you that. It will become a full toss and you know where the ball will land. So therefore, I will make an attempt with this in mind. Now on this simple issue of AI being used in judicial decision making, I intend putting in 5 caveats. 5 caveats only as the devil's counsel, because a word of caution is all that I'm intending to put in. 1, a statute to regulate the use of AI is imperative. Yesterday, in the inaugural, Brother Mushtaq was insisting that we should, emphasizing rather, that we should have a statute which regulates the AI. Interestingly, I find one of the co-speakers today, Mr. Abhivardhan, Mr. Abhivardhan has put in a bill which says regulation and development of AI 2023. He has suggested it. I stumbled on it while doing some research for this session. And there he has defined, given a definition for AI. AI, to my mind, is difficult to define, maybe capable of being described. But nonetheless, he has made an excellent attempt. But reverting to the position I hold, I do not want to say anything just in case there is a statute tomorrow and there is a challenge to the same. But a very good effort. But most importantly, he has also suggested classification of AI based on technology, content, and he has even suggested a classification based on risk-centric assessment. That is very important. And that is the reason why I would refer to Loomis's case in US, where a tool, Compass, was used, a recidivism tool was used for sentencing, and Loomis, the convict, assailed it. While assailing it, he said, the algorithms are there, the conclusion is here, but where is the dispositive reasoning? I don't have access to the algorithms. Therefore, I don't have a right of appeal. My right of appeal has virtually been neutralized. So the good takeaway in Loomis's case is, the Supreme Court of Wisconsin answers the first caveat very nicely. It says the two terms rely and consider are being used interchangeably. But when it comes to AI, please don't do that. Only consider, don't rely. That is caveat number 2. I know I'm 30 seconds past 4 minutes. Now I'll go to caveat number 2. Caveat number 2 would be on jurisprudential stagnation. The possibility of jurisprudential stagnation, this is caveat number 3. Statute is caveat number 1, using AI without a regulation, and caveat number 2 is consider, don't rely. Caveat number 3. Jurisprudential stagnation is quite possible. The simple question I ask myself and place before this august audience and the dignitaries on and off the dais is this. If AI is going to be used for judicial decision making, who will write the dissent? After all, in privacy, 3 momentous dissents have been made law, and it is now the position that dissent is future intelligence. Now this evolving, this jurisprudential development march of law may get started at some point of time, and therefore it is very, very important, and there I suggest that we look at only cyborg judges and not robo judges. Here take even Estonia, where up to 7,000 euros cases are decided by robo judges. There is a provision for an appeal to a human agency. Therefore, next caveat would be always look at cyborg and not at robo judges when we use AI for judicial decision making. And then of course on invention itself, it may at some times become a casualty, because Nick Bostrom, as all of you might know, the Swedish philosopher who heads the Future of Humanity, an entity in Oxford, after doing a detailed research on existential crisis for human beings, said AI may be the last invention human beings make. And he was widely criticized to be a doomsayer. But we will look at him as one who has put in a very nice caveat. He said machine learning may take over and machines may start inventing more intelligent machines. I am into the last minute of my was the time allocated to me, and therefore I would conclude with the last caveat and one addenda. The last caveat is the digital divide. When you use AI, the Puritans on the other side of the digital divide may say, sorry, dispositive reasoning is a casualty, and there may be another end of technical, the enthusiastic end users who might say, look at the speed at which the decisions are taken. Therefore, this possible polarization will widen the digital divide. This should not happen, and that is the last caveat. And I would conclude with this. I have put in something by way of material on global practices, because that is also part of the sub-theme. And global practices around the world I've taken in Ross, I've taken in Hart, I've taken in even Thomson Reuters learning machine, which helps judges to familiarize themselves with technology. All that I have put in. I will leave it with the organizers, and my humble suggestion would be maybe we can consider bulk mailing this to all of us so that we can ponder over that, and in the days to come, in conferences to come, we may deliberate on those practices world over, the global practices, so that best practices, global best practices are available to us to adapt and also adopt, taking into the local conditions. Thank you very much for the opportunity. Thank you for the patience, and make an attempt in the local language, namely the regional language. Nandi and Valare Nandi. Thank you.
Thank you so much, sir, for your very strong caveats. May I now invite our very gracious and dynamic host, Honorable Justice Mushtaq, Acting Chief Justice, High Court of Kerala, to please share his thoughts with us.
Honorable Chair and co-chairs and other dignitaries on the dais and off the dais, I'll try to be as brief as I can, if possible. And for the last 5 years as a computer committee chairman of Kerala High Court, I want to share my experience of building an IT infrastructure for Kerala High Court. I think we need a certain conceptual clarifications. Everybody and whenever we go for any conference and any other meeting, we'll discuss what kind of application we needed, what kind of program we needed, and all complaints that we don't have programmers and developers and others. I think we need in place, first of all, a conceptual idea behind enhancing capacity building. So I'll share my experience and I'll share my thought. Essentially on 3 points. First, less human intervention and more certainty to be brought in the courtrooms, and whether it's related to listing of the cases, whether it's related to the intelligent listing of the cases, classifying, categorizing, prioritize all type of cases. So there should be a less human interventions, and there should be more predictability and certainty in the courtrooms. That is not happening in the courtrooms. When I speak this in Indian context, I mean, maybe the Roni might be wondering, in India we have 51 million cases total pendency. And our judge population ratio is 21 judges per million. So we are handling a volume of cases. So there should be more certainty in our courtrooms. If anyone asks what kind of a productive hours we've spent in the courtrooms, though we sit around 5 hours in a day, our productive hours may be less than 3 hours. So we need to have a more certainty in our courtrooms. The algorithm can fix it. We need to fix our timeline of cases, rather unscientific way of fixing the targets for the district judiciaries. So often we say that dispose this much of cases percentage. So technology can fix this issue. This is the first thought. The second thought is on justice as an idea as of emancipation. The 10% of our cases, total pendency, is related to motor claims in any courts in India. Today the data can interpret. What court need to oversee is validation of those data and ensure the authenticity. You might have heard about how the smart contract function without any intervention of third parties. All this is possible in this technological era. The data can be interpreted and it can bring results. So what's the role of the court in such situation? Is to oversee that and validate those data. This is the second thought I have on this problem. The third and last is the prudent use of human resources and other user resources. The many cash-strapped states are unable to establish new courts. Given my state also, I find this difficult. Not many other states, unlike states like Gujarat or Punjab, of course, they sanction the courts easily without any much hesitations. But many cash-strapped states are unable to establish new courts. Why? Because we are not prudently using human resources. Many of our work is a duplications. It goes in a different level. And Rajesh Bintal, the judge of the Honorable Supreme Court, conducted a study, and he said we have make 25,000 entries in the physical form, and there are around nearly 1,450 registers we maintain. How much human resources we require for that? These data can be fetched. So there should be a prudent use of human resources and other resources. And that is where the technology comes in. We're trying to fix in Kerala High Court. We have started machine scrutiny. As a result, we can disengage around 60 filing scrutiny officers. Many work is duplications. In district judicial also the same thing is happening. So 3 focal points we need to have. Unless we have a conceptual clarification on the engagement we are now, all of us, many of us are doing it as a part of computer committee, I don't think we'll be able to make results. People often ask, the lawyers would ask us, there is no visibility, though there is e-filing in the place. They anticipate a change immediately after e-filing. It will take years because there should be a business process engineering should happen. Now, yesterday we inaugurated around 14 digital courts in the state. When we asked, the government asked whether there would be an additional manpower is required, we said we don't require. We'll engage, we'll find out a surplus staff within. If we say that we require an additional staff in each court, which may require 12 to 14 supporting staff. If we say, yes, we require, then government would not sanction. So we should prudently use the resources, financial resources, as well as human resources, so that we can establish more courts with all limited budget sanctions provided by the government. So my brothers who are here from the different high courts, we need a conceptual clarification. This is the only way we can proceed further with our building in capacity for a judiciary, without which, and such an engagement and conversation on these areas, we will not, because all our, sometimes it's, when I spoke last week also in Chandigarh, all become directionless. We need to focus with certain directions, and there should be clarity on thoughts. There should be clarity on our concepts, without which we cannot have an engagement on building, we cannot enhance our capacity. Thank you, one and all.
Thank you very much, sir. May I now request the last speaker, Mr. Abhivardhan, who's Managing Partner, Indic Pacific Legal Research, and also Indian Society of Artificial Intelligence and Law. We already heard about some of his work. The floor is yours for 8 minutes.
Respectfully, it's an honor to speak in this prestigious forum, and I'm grateful to Justice Sundar for having had a look at AIAct.in. So in my work as a technology law specialist, my concern around AI policy and the way it has been growing in India and the larger Indo-Pacific was more around that if we really think that regulation is possible in India and we really think that it should be tried, then in principle and practice, what could be the differences? Because a lot is centered around existing legislations, be it in the European Union or China. The discussion is around those issues. But my intent was of drafting AIAct.in was more around at least addressing the problem that if we really think that regulation is possible, then how would it affect the larger AI community in India? What would be the ramifications from a public law angle? Because although not proposed in the draft bill, but it might become necessary in maybe 5 to 10 years that as more public-private partnerships and public interventions using AI technology happens, maybe we need to ensure that the right to information also extends to certain kinds of AI, at least in the public, not in the private side, obviously, not in the proprietary necessarily, but at least in the public sector side, even if it is open source or not. So I will divide my, I would say, insights into 2 parts. First, I will a bit talk about the scene of how AI policy has been in the Indo-Pacific and India largely, and a bit adding to the existing insights in a more interesting fashion. So this is, and the second part, I would be addressing the 2 key topics of this session, which is already around case management and best judicial practices for the country and beyond. So when it comes to AI policy, I was honored to speak and provide my insights in a G20 Brazil Startup 20 technical meeting, in which the questions were around whether the national AI strategies and policies are working out. Now, for any digital public infrastructure, be it in the executive or otherwise, the judiciary is also, a beneficiary of the digital public infrastructure. And we have seen some amazing use cases, especially yesterday when we saw how the High Court of Kerala's dashboard actually is workable, sensible, and is a good start for inspiration for many high courts across the country. In that regard, I had shared some basic points that, and I think they were more in the administrative side of things, but they also apply in the case of the judiciary. That first of all, there's an AI divide. Now, since the data protection law has already been passed and it will be implemented soon, we will have the data protection rules in a few weeks, hopefully. The one problem is that as the digital divide has already been there, the AI divide is also going to affect a lot of, I would say, consumers and citizens alike, because at the end of the day, the role of algorithms itself, it needs to be explainable and clear. And while technological explainability is one facet of it, beyond that, there are trust-based aspects as to how you familiarize with any class of technology or the use of data. It's like using basic technologies in India's stack like Aadhaar or UPI or DigiLocker. The more we familiarize with DigiLocker or Aadhaar or UPI, the more we trust it, because we understand the limits of what kind of data is probably taking, how it is working, how it is familiarizing. So of course, familiarizing with AI is necessary for every stakeholder, from citizens to members of the bar, to even judges and relevant judicial officers and relevant, I would say, stakeholders within courts. So that is definitely a part around AI divide. The other aspect, because I was discussing with a venerable judge, I think Justice Pandanathan from Malaysia, and we were discussing about this point that maybe while technological innovation is happening, we really need to think about, in part, not full, maybe decolonizing some part of our systems which are already there. Not merely from a statutory basis, but also from an understanding of how it affects human interactions and how are we creating a trust-based infrastructure. Because having a culture of solutionism is great, which is appreciated, but that may not solve the entire problem, because a lot is around maintenance, a lot is around human technology interactions. I think they are minute issues, not so advanced issues, but still they would affect our journey of technology governance, howsoever we use AI in case management and other aspects. To add on that quickly, now I will move on to the 2 points of this session, which are about case management and judicial best practices. So one of the things which I would be happy to propose is that while we need better case management systems in future, we will have them. I think we should try for them. We already have a good ecosystem of people who are trying to understand it. I think knowledge management protocols is a must for every single institution, be it companies, be it anyone. Because the way data quality works, the way data flow optimization matters, and the way certain minute aspects of privacy at across levels comes in, I think that creates a paradigm that we should be concerned about. Another thing which I found interesting to suggest was more around design thinking. So recently, I think I would say the Federal Court of Thailand, or the Supreme Court of Thailand as we say, they actually organized a Justice by Design initiative in collaboration with United Nations Development Program. That was very interesting because it works on 5 key areas. And the 5 key areas are very simple. So whenever you integrate technology or you have a technology-centric management solution, anything, the first is obviously you identify a problem. That's the basic thing that any institution has to do. Second, I think since access to justice is the core fundamental behind any aspect of judicial governance, because at the end of the day, judicial governance is also governance. It could be around a minor aspect around, traffic challans, or it could be at a higher level about certain reliefs, maybe to request to issue writs under the Constitution. So considering that, iteration becomes important. In that regard, empathy is very necessary. How much sensitive are we to the kind of infrastructure or the kind of deliverable we are coming up with? And then, of course, iteration, prototyping, those things come up. But largely, yes, since Justice Sundar referred to AI Act.in, I'll be very quick on getting on AI Act.in. So this act was proposed by my own understanding of how it is happening in India, because again, control and regulation are 2 different things. And while we don't have a larger evolving market understanding yet, which again depends because startups, SMEs, and legacy companies behave differently, even in the case of open source. The necessity to understand and get feedback as to what regulation could be possible was the point. So I classified AI into 4 points, into 4 aspects. First is a conceptual way to do in substantive law. It could help in intellectual property disputes. It could help in certain contractual aspects, sometimes around phenomenal changes or something around force majeure. The second aspect was around technical methods of classification to see how technically we can divide and stratify AI. So, one of the ways that the European Union did was general purpose AI. That is a part of the proposal. But others were also included, such as specific purpose AI with specific use cases, smaller access approaches and things, limited use cases, not like a ChatGPT which offers you everything from making an itinerary to making a draft of a petition, because I tried that. Yes. And with that, the two other classifications were commercial methods and risk-centric methods. To conclude further, I think across institutions, when it comes to DPI, in the executive side, in the judiciary side, we really need an evaluated and precise understanding as to how AI or any other digital technology can help us. And I hope that if AIAct.in is something which intrigues all the dignitaries here, I would be happy to have a feedback of the proposal. And we have already come up with a version 3 in June. We will come up with more versions. And yeah, it's a pleasure to speak. I'm already done.
Thank you so very much, Abhivardhan. Now we move on to our discussants, and we have 6 of our very eminent colleagues. And since the first of them is Honorable Justice Saurabh Banerjee, Judge High Court of Delhi, who happens to be an excellent cricketer, I just want to remind all the discussants that you are brought in only for 1 over. So please make sure that you go for a 6 in every ball. 3 minutes, sir. Thank you.
Good afternoon. I love T20. I'll play T20 only. Honorable Chair, Honorable Co-Chair, other Chief Justices and the judges of the courts of this country and justices from abroad, on the dais, off the dais, learned Attorney General, ladies and gentlemen, a very good afternoon. Hello, ma'am. How are you? It's been more than an hour. You can please feel free to take a 5-minute break, tea, coffee outside. I'll be there. I'll be holding the fort. I'll manage till then. I don't need your. Pardon me for saying, the most word used since yesterday till now, and I presume later also, is time. As it's said in Hindi, Samay bada balwan hai. Time is highly powerful. So I'm glad that I was given 3 hours for each exam when I qualified for law. Being mindful of that, and I assure you, all of you, I follow the IST, Indian Standard Time. But it's only when I'm tempted to follow the IST, Indian Stretchable Time. So please pardon me if I do so. Given the time frame, I'm to finish, I'm to finish within, and what I've been hearing since yesterday of the sharings of the August gathering, since I consider myself lucky to be a discussant in the last session and I can verily say, quote and unquote, I agree and I adopt the discussions. Thank you. However, on a serious note, not to take much time of all those present, especially since we're on the verge of dispersing for our lunch, I'll simply share with what I have gathered after hearing the eminent speakers across all spheres from yesterday. My time starts now. For this, broadly speaking, I'll categorize and equate the 5 takeaways identified by me with the 5 fingers of a hand, particularly since each of the fingers of our hand are no doubt distinct and singular, but also have a role to play collectively. The index finger for me denotes cost effectiveness. What each one of us does has a figure along, and when it comes to cost, the less the better, since it will be more productive and will give more in less. Similarly, the thumb for me denotes time management. It takes time and effort for each one of us to do anything. So what means is how much time it would take to do that thing. We are all living in an age where time is of immense value. The middle finger for me denotes user-friendly. Ease and understanding is in all that we do is required at all stages. More so, since it would lead to generation of a broader base and many joining and many more following. The ring finger for me denotes safe protection. Caution and care are the strong pillars with immense relevance at all stages in all that one is contemplating to do or doing or finding a way to meander for reaching the end. Lastly, the small finger, as per me, denotes data sharing. Creation and knowing what one does or what all to do is meant for sharing needs caring. Moreover, since we are always on a need to know basis and we would be inept if we are not sharing. Thus, in my opinion, each of the above in their own respective ways are tools for enhancing our efficiency. That which we all are looking for today and also in the days to come. Not to miss that for all the above, we need the most able and efficient system giving us, if not all, but at least the maximum possible solutions. According to me, for a successful implementation of each of the above, we have to enhance the efficiency using technology for building a robust case management network. There is a recent growing trend globally for building a case management network with all the above. And there, 1 minute more. Globally includes India, as India is not far behind, since though it may not be the harbinger, but it is certainly a torchbearer in adopting and continuing with the case management network at different levels and spheres, including the Indian legal system, infrastructure, engineering, to name a few. Finally, before bidding adieu, I want to part by saying we are all gathered since we do need to have a case management network for enhancing our efficiency in the field of transport and tourism, to connect them with technological innovations, as we are living in a technologically driven society, requiring us to change with times. Lastly, we must always remember that we are all a part of nature, and nature is not a part of us. Thank you, listeners. Jai Hind.
Thank you very much, sir. May I now request our gracious guests from Fiji, the Attorney General for Fiji, Mr. Graham Lewing, somebody who took the maximum amount of time to come here. The flight from Fiji to here was 18 hours. Thank you, sir. Sorry, we are only able to give you 3 minutes.
Thank you, Madam Additional Solicitor General. Honorable Chief Justices, Honorable Judges, Honorable Attorney General of India, fellow panelists, Honorable Chair and Co-Chair, ladies and gentlemen, students. I want to begin by first mentioning that your esteemed President, Srimati Tirupati Murmu, made a state visit to my country, Fiji, 2 weeks ago, underscoring the warm and cordial relations between India and Fiji, a relationship that goes back more than 1 century. I'm delighted to be here and very conscious of the fact that time is of the essence. Fiji's judiciary launched its digital case management and e-filing system on the 30th of January in 2023. That system is still in its infancy. The initiative also included the establishment of an e-help desk, the provision of hardware for data backup, and training for the utilization of the e-filing system. The initiative aims to improve the provision of efficient legal services and information and establish a system for monitoring, analyzing, and reporting on case trends to strengthen accountability and transparency in judicial procedures. It shifts away from the manual filing and case management system, which is often costly and time-consuming, as we heard from the previous speaker yesterday. From previous discussions, I note that whether it's sustainable tourism, transport, or technology innovations, accessibility, affordability, and efficiency are key components to its success. Ladies and gentlemen, when Fiji embarked on a judicial transformation program, including the judiciary's e-filing and digital case management system, the challenge for us remains that technology evolves over time, that is fit for purpose and requires continuous training, capacity building, and upskilling of human resources. This can be a particularly onerous task for a small island developing archipelago of several hundred islands like Fiji, where human and financial resource constraints coupled with adverse impacts of climate change are threatening the health of our people, food security, and economic and social development. Ladies and gentlemen, this conference has been a great eye-opener for myself and my colleague. Fiji can learn best practices from India, which is far advanced in technology. All the speakers in the last day or two have brought remarkable and fresh insights into the common challenges that we face in dispute resolution before the courts. Fiji is steadfast in its commitment to digital case management systems and e-filing. Ladies and gentlemen, the role of the judiciary is to administer justice in a timely manner. And I'm cognizant of Article 21 of the Indian Constitution, which embodies this promise. Article 15 of the Fijian Constitution has a similar provision. I note that one of the speakers yesterday said that it can take up to 10 years for a case to be disposed of in India. Fiji has a similar problem with case delays in the courts, and we can learn and share best practices. AI and technology has the potential to optimize capacity and deliver speedy justice, which is a constitutional right of our citizens. But as previous speakers have noted, AI has its limits. It can never replace or supplant the virtues of human compassion and empathy. These are unique to human beings and can never be replaced by machines. In the final analysis, human beings must never be enslaved to machines or technology, because if we do that, ladies and gentlemen, we risk losing our soul as humans. As we move forward, we must ensure through regulation and laws that issues of data privacy and ethics are taken into consideration when we consider embracing AI and technology. Thank you for the opportunity to be present at this conference.
Thank you, sir. May I now request Pradeep Bakshi, sir, Advocate, Supreme Court of India, to share his thoughts.
Honorable judges on the dais and off the dais, distinguished guests, and my dear friends. Adoption of best practices and technological tools can surely improve decision-making and case management and ensure speedy resolution of disputes in courts. However, there is a caveat here. For technology to be effective and efficient, it is very crucial that there is synergy between different management softwares in use, especially in courts. While reviewing the reference material for this session, I came across this critical fact. That in a three-tier judicial system that we have in India, they all use different case management software systems. Some use the case informative system developed by NIC, others use software systems developed in-house teams. Supreme Court uses its own integrated case management information system. Though by use of technology, we have created an island of information and data, but by different variants of case management software and systems, as mentioned above, the result is, to give an example, trial court records is not achievable in spite of the fact that we have invested heavily on technology with major thrust on digitization and content creation by the courts, otherwise freely available in data format. So the question is, what is the way forward for proper utilization and use of technology so that the stakeholders are able to file, list, manage their cases via case management systems? I suggest that there is a need for different care management systems to sync and talk with each other, and there must be free transmission of data amongst them. There should be a uniform adoption of case record mechanism by courts at all levels that will enable mapping of case-related information and data, and more importantly, enhance capacity building and strengthening skills sets of stakeholders, that is the lawyers, court staff, and the judges, by organizing periodical training sessions to keep pace with fast evolving technology. Thank you.
Thank you very much, Bakshi sir. May I now request Mr. Rajiv Essas, Advocate and Executive Member, CLEA, India, to share his reflections.
Thank you, madam. I am a trial court lawyer practicing in Thiruvananthapuram, the capital city of Kerala, and I am here to share my experience in the trial courts with respect to advancement of technology in trial proceeding. I do concede that technology has embraced the subordinate judiciary. Initially, sharing our experiences from 2005 onwards, there was a lethargy on the part of the lawyers as well as the judicial officers in imbibing this technology. And the two-time efforts in 2005 and 2013, digitalization of courts couldn't take place with the expected pace that it should have arrived in the trial courts. And the reminiscence of which we could find in each of these courts in the form of the old erstwhile computer monitors, junction boxes, and outdated batteries we can still find in the trial courts. Now, anyway, thanks to COVID-19, it is the technology has embraced the trial court proceedings also. But whether it has produced the required results is a challenging question. The first of its issue is with respect to the listing of the cases in the courts. And thankfully, Honorable Justice Mohammed Mustaq has highlighted that they are in the process of implementing the machine listing of cases, machine selection of cases for listing of the case. Because as those who are present among the audience who are having connection with the district judiciary will be aware that most of the time of the court management daily routine goes away with the roll calls. And the productive time left for trial of cases is only almost 2 or 3 hours, that too in the post-lunch session. So listing of the cases requires a very advanced technology tool supported by artificial intelligence for listing of these daily routines. Now, the CIS or the case information system that has been implemented nationwide by the NIC has brought in good results with respect to transparency. For the litigants as well as the lawyers themselves, they can follow the chronology of each case which are listed, which are pending in the cases, and the proceedings, stage of various proceedings can be discerned from the CIS itself. But the question is that whether now we have entering a third phase, that is with respect to e-filing. Now the e-filing has created so much controversies as well. Yesterday or the 2 weeks prior to this, the president of the High Court Bar Association itself has raised his concerns with respect to e-filing. Personally, I don't endorse his views on that point. But however, the reservations that the lawyers, especially those who are outdated in their profession with respect to technology, are to be tuned up with this electronic process, so the technological advancement. Now, with respect, he has also hinted that there is not an electronic court in the Kerala High Court itself. Now, we have got a paperless court in Trivandrum, that is the Additional Chief Judicial Magistrates Courts. While going there, we feel that whether sustaining a e-court or a paperless court at that much expenditure is really necessary or not, because of the paraphernalia that is attached to it. Now, the two questions. Whether technology has advanced the judicial process, yes, to a certain extent. But whether the technology has expedited the judicial process in the trial courts, it is not. It is the results are yet to be revealed. Now, yesterday, I was really impressed by the presentation that was made by Mr. Utkarsh Saxena of Adalat AI. That presentation addressed most of these trial issues, even with respect to taking of depositions using AI-assisted tools. That is said to be imbibed by the judicial officers of our lower courts. That would be, those suggestions would bring out positive changes if they are implemented in toto. Thank you.
Thank you very much, sir. May I now invite our friend from Colombo, Mr. Rajiv Amar Surya, to please share his thoughts.
Respected Chair, respected Co-Chair, Honorable Judges, Attorneys General, ladies and gentlemen, good afternoon. It is wonderful to be here in Kumarakom in Kerala, a state and a city that has many commonalities with my beautiful country, Sri Lanka. Thank you to the organizing committee and the state of Kerala for the very warm welcome extended to us. Law and technology focusing on sustainable transport, tourism and technological innovations, to me, this is probably one of the most important areas that is now presented to us in our region and across geographical boundaries. We are speaking in this panel on the introduction of technology in our court system, and much has already been spoken on the pros and the cons. Ladies and gentlemen, we are on the cusp of a transformation of the way we do things, the reality of which I do not think we fully appreciate or understand even as of date. To provide context to what I am saying, I do not think we will have conferences in today's format 2 to 3 years down the line. The way we do things will be very, very different. And this is because AI also reinvents technology at exponential speed. I would like to take this opportunity in this concluding plenary of this conference to endeavor to provide some conceptual grounding to what we discuss. And for this, I draw parallel and inspiration from the Bangalore Principles of Judicial Conduct of 2002, where a fellow Sri Lankan and a close relative of mine, Dr. Nihal Jayavikrama, was very closely associated with. There can be no doubt technology can support and assist these values of independence, impartiality, integrity, propriety, equality, and competence and diligence. For instance, the sixth value of competence and diligence speaks of the judge's duties and tasks in relation to court operations, taking advantage of training, being informed about relevant developments of the law, and of course, delivery of reserved decisions efficiently, fairly, and with reasonable promptness. No doubt technologies such as AI and blockchain can definitely support this. The emerging technologies and judicial integrity toolkit for judges by the UNDP, which was spoken of earlier, is a development in this area. The point I wish to drive, ladies and gentlemen, is that it is no longer an option available to the courts, but a mandatory duty and responsibility to take on technology proactively, effectively, and of course, with responsibility to further develop our systems. And in my view, and in my humble view, as time progresses, failure to make use of available technology will be a dereliction of duty as opposed to anything else. Ladies and gentlemen, as many predict, there will be a time sooner than later when it would be considered prudent and reasonable for even a first draft of judgment to be generated by AI. And as I said before, we are still on the cusp of this transformation. And I'm sure with the development of technology and AI, even dissenting judgment would be produced through this technology. In conclusion, let us together, and with support from organizations such as CLEA, focus on finding ways, means, and measures to avoid the pitfalls and overcome the hurdles in using technology to make more effective a third pillar of democracy. Thank you very much.
Thank you, Mr. Amar Surya. May I request the last of our colleagues, Mr. Akhil Suresh, Senior Partner, Bhartis Legal, to please share his reflections.
Honorable Chair, Co-Chair, dignitaries on and off the dais, ladies and gentlemen. I have the disadvantage today of being the last address of the day. Whatever I intended to say is already covered, or whatever I wish to say is already spoken about. Today, I wish to speak of one single topic which is now left, is with respect to the technological advancements that has come in from the perspective of a lawyer. I'm a lawyer practicing within the state of Kerala. And I have been here for the last 3 years. I've actively been watching how the e-filing and our portals have been developing in the last 3 years. And something to connect to our topic, which is with respect to sustainable transport, tourism, and technological innovation. I must say with immense pleasure that our High Court is one of the first High Courts which has actually achieved the dream of paperless courts. And I have the privilege to say that is because tomorrow I have 7 cases tomorrow. All I need to approach the court is just my iPad, because the High Court of Kerala app, which has now come out, has all pleadings which I have filed, all pleadings which my colleagues have filed or the respondents have filed, and everything is available in my pad. So that is all that is there, and that is all that is required. I would, however, say that there is so much more to achieve, even for our e-filing portals. And the way forward is by implementing and utilizing open source softwares, because we are well aware of the fact that the courts, again, are struggling with allocation of funds. I was pleased to hear yesterday that about 7,000 crores is now being allocated for the purpose of implementing as well as developing court softwares and other softwares, which is beneficial for all stakeholders. Now, coming to certain specific areas which can be benefited, I am moved by the presentation which was made yesterday by Mr. Utkarsh, where transcription of documents is one of the key elements. And I would only wish to add that the focus of Adalat AI was only to the district courts as well as the lower courts. But what we need to also understand is that the features which was promoted is something which is very useful for lawyers as well. So we as lawyer fraternity should also have the advantages of tools. And now with some research we have found that there are softwares which are open source softwares such as Whisper AI, which transfers speech to text. And we already have existing software such as Dragon and all of those other which in fact is much more. So another thing which is with respect to I wish to speak something about a stenography device. This is something to do with typing and recording the court data, which is a difficult task as on today. If an average person can type close to 30 to 40 syllables in a minute, the stenography machines, which now is already implemented in the US courts, are able to record close to 220 to 330 words per minute. And this device today costs close to 3 lakhs. If we are able to recreate such a device here with the implementation of certain open source software such as Plover, we will be able to recreate a machine, reduce the cost, and bring up a product which is somewhere will cost you around 80,000 rupees in Indian rupees. Finally, to conclude, I'd like to share an interview which I recently saw of Mr. Dr. Virendra Kumar. For those of you who don't know him, he was an ex-member of parliament, the director of Madhurabhumi News and Telecom, also a writer, a teacher, and a planter. So in one of those interviews, he was asked by the interviewer as to how he efficiently manages his time. And then he immediately points his finger at his table and shows 2 files which were there on that table. And then he says that if you don't actually have the time to do something you were supposed to do, then you're actually doing somebody else's work. So this is what he had said, in fact, and this has landed to me very well. and at the same time we'll have to take cue from these words and to understand how AI and technology has to be implemented in the courts, as well as for all stakeholders, which includes lawyers, litigants, as well as judges. Here it is only an accelerant, and it is only for the purpose of upskilling every person and not intend to replace anyone. Thank you.
I am very sorry for passing all the slips. That brings us, with the permission of the chair, to the conclusion of this session. And may I, with the permission of the chair, request the Learned Attorney General for India and Professor Shiv Kumar for the felicitations. Sir. So it's clear the winds of change are blowing fast and furious. Let's take all the caution, the caveats, and build good windmills rather than making walls. And we can keep improving on the design of our windmills. May I request Attorney Sir and Shiv Kumar Sir to facilitate the chair of our function of this session, Honorable Justice Prashant Mishra Sir, Judge, Supreme Court of India. Thank you for steering us towards solutions, sir. And thank you for allowing me the caveat of the Supreme Court judge to escape the contempt from the High Court judges. May I request, sir, to please facilitate the co-chair, Honorable Justice Vinod Chandran Saab, Chief Justice of High Court of Patna. Thank you, sir, for giving me 2 extra minutes out of your time so that I could make my suggestion also. May I now request our friend from Nepal to be... we already facilitated our Nepal judges, and now may I request, Sir, Honorable Justice M. Sundar, kindly felicitate, I'm sorry. Kindly felicitate Honorable Justice M. Sundar for the strong cautions. Thank you, sir. May I request you to kindly felicitate Dr. Justice Anita Sumant ma'am for sharing very interesting 4 points from her session. May I request kindly present the memento to Honorable Justice Sundar Govindraj, sir, Judge, High Court of Karnataka. And I apologize again, sir. Please don't time me when I come to appear before you. May I request Abhivardhan, our young colleague, please come up here, Managing Director, Indi Pacific Legal Research, Indian Society of Artificial Intelligence and Law. Mr. Abhivardhan.
Okay.
These youngsters are leaving indelible marks on us. Yesterday, Utkarsh, today Abhivardhan. Thank you for all the good work you're doing. Our cricket judge, Honorable Justice Saurabh Banerjee Saab. May I request Learned Attorney and Shiv Kumar sir to felicitate. And the Attorney General from Fiji. The Attorney General from Fiji, please, please, sir. Mr. Graham Lewing came a long way and shared the perspectives. And the conversations on the tea time were also excellent with the Attorney General. May I now request you to please felicitate Mr. Pradeep K. Bakshi, Advocate, Supreme Court of India. Thank you for sharing your perspectives, sir. Mr. Rajiv, the trial court perspectives, sir. Rajiv, sir, I can share one of my experiences. I keep on telling my colleagues that either you come to the iPad and use technology or we will become dinosaurs. So I think we have to, as lawyers, we have to impress on our colleagues more. Thank you, sir. May I now request you to felicitate our colleague from Colombo, Advocate Rajiv Amar Surya, for sharing the perspectives from Sri Lanka. And the last of our colleagues, Mr. Akhil Suresh, Senior Partner, Bhartas Legal. Thank you for your take on how you carry the office on the iPad. And more strength to you. Please convert 10 of your colleagues every month. And we are grateful to the gracious host. Thank you very much. And now may I invite Ms. Payal, yes, a memento for Ms. Payal Ajmera. She can be felicitated and then give the vote of thanks also. Oh, sorry, I Vice President of CLEA, Bar Council member, Mr. Yayappa Mani also, sorry. The first name I missed.
Alphabetical order.
And over to you, Payal, for the vote of thanks, please. Oh, the Attorney General for Fiji has a gift for the Attorney General of India. And
Good afternoon, everyone. On behalf of Commonwealth Legal Education Association, I, Payal Ajmera, extend sincere gratitude to everyone who contributed to the success of Technical Session 4 on enhancing capacity and decision-making, policy, law, and justice. We deeply appreciate our esteemed Chair, Honorable Mr. Justice Prashant Kumar Mishra, Judge, Supreme Court of India. Co-Chair, Honorable Mr. Justice K. Vinod Chandran, Chief Justice, High Court of Patna. And Keynote Speaker, Honorable Mr. Justice Anil Kumar Sinha, former Judge, Supreme Court of Nepal, for their expert guidance and insights. Our heartfelt thanks to all the distinguished speakers and discussants for sharing their valuable expertise. Mrs. Aishwarya Bhatti ma'am for her skillful moderation and the rapporteurs for their diligent work. We are grateful to all the attendees for their active participation. Your collective contributions have significantly enhanced our understanding of technology's role in advancing judicial systems and practices. The success of this session is a testament to the collaborative efforts of all involved, for which we are deeply grateful. Thank you.
thank you, sir. Thank you, sir. We can wind up the session. We are very grateful. And I have an announcement. We have lunch downstairs in the restaurant. You just go down and left. And we have the valedictory session starting at 2:30. So please be back at 2:15. Thankfully, or unfortunately, it won't be Sadhya. So have a quick bite, quick chat, and come back up here for the valedictory. 2:15 back here in the hall. Thank you very much. And I apologize again.
I have one request.
Yes, sir.
I require the latest photos of your brother. No, all LiveLaw photos of 20 years old.
Yes, sir. That's right, sir.
I wrote to him.
I'll take one and send you, sir.
Others may be waiting for lunch. Thank you.
Thank you so much, sir.
happening at any moment. Dear all, may I humbly request everyone to raise and offer a warm and respectful welcome to our esteemed guests as they enter. Dear all, I humbly request everyone to rise and offer a warm and respectful welcome to our esteemed guests. Esteemed guests, distinguished dignitaries, colleagues, participants, and friends, we have reached at the culmination of what has been an insightful and thought-provoking conference. It is with great optimism I welcome you all to the valedictory ceremony of the Commonwealth Legal Education Association International Conference on Law, Technology, Sustainable Transport, Tourism, and Technological Innovations. To commence this valedictory session, it is my honor to invite Professor Dr. S. Shivakumar, Conference Chair, President of Commonwealth Legal Education Association, and Senior Professor, Indian Law Institute, to present the conference report and the Kumarakom Declaration.
Chief Guest, Honorable Justice B.R. Gawai, Judge Supreme Court of India, Honorable Justice Mr. Suryakant, Chief Patron and Judge Supreme Court of India, other honorable judges from Supreme Court, Chief Justice from High Courts, judges of High Courts, abroad jurisdiction judges, distinguished speakers, esteemed legal professionals, colleagues, and my dear participants. Very good afternoon to all of you. It is with a deep sense of gratitude and pride that I welcome you all to the valedictory ceremony of Commonwealth Legal Education Association International Conference on Law, Technology, Sustainable Transport, Tourism and Technological Innovations. I am contented to have witnessed the meaningful deliberation and collaborative spirit that have characterized this gathering. I extend heartfelt welcome to our chief guest, Honorable Mr. Justice B.R. Gawai, Senior Most Judge of Supreme Court of India. Lordship's steadfast commitment to justice has left an indelible mark in our legal system. The insightful judgment and dedication to upholding rule of law continue to inspire all. Lordship, welcome to this function. My sincere welcome to Honorable Justice Mr. Roni Govindan, Chief Justice of Republic of Seychelles. Your participation has added immense grace to this function, Justice. We don't know how to thank our chief patron, Honorable Mr. Justice Suryakant. This entire, from each word to just now we are sitting here, all monitored by our Honorable Justice Mr. Suryakant. He is the chief patron of CLEA. Wherever we are going with any problem, any issues, any challenges, there is a solution from Lordship. Lordship, for courtesy, we are welcoming you to this function. Please continue this patronage. Dr. R. Venkatramani, Learned at India, the chief patron of CLEA. I can again express my thanks to him. He is the source of inspiration and he used to always monitor things. That's why this met this. We are very much thankful to Honorable Kumar, Honorable Mr. Justice P.S. Narasimha. We don't know, Lordship is having, we can say an academic judge we have, and he's taking so much interest. When we had that Attorney General's conference, that you all to this function. We have Solicitor General also, he's also very much helpful for Commonwealth Legal Education Association. I thank each and everybody, especially speakers, discussants, and also the other people, those who are gave directly and indirectly inputs, including our Honorable High Court judges. I am also thankful and I formally welcome Honorable Mr. Justice Muhammad Mustaq, Acting Chief Justice of Kerala High Court, Justice Dias, Mr. Loknath Behra, Dr. Girish Shankar. Their implementation we have witnessed here. Thank you. And from my side, I am extending welcome. As we bring this today's journey to close, it is evident that our conference has captured the essence of where innovation meets action. While this was not explicitly set as our theme, it perfectly captures the essence of what we have achieved. Our discussion have transformed into actionable strategies and will continue to drive meaningful change and address the challenges before us. The conference has emphasized the importance of resilience, capacity building, and ability to adapt. The insight we have gained highlight the urgent need for comprehensive legal and ethical framework to address the challenges posed by emerging technologies and sustainable practices. As we come to the end or conclusion of this remarkable gathering, it is my honor to present Kumarakom Declaration 2024. With the permission of Honorable Chief Guest Justice B.R. Gawai and Chief Patron Honorable Mr. Justice Suryakant, this declaration embodies our collective vision and commitment for the better future to address pressing issues discussed throughout the conference. Lordship, may I this declaration? I read, we, the participants of Commonwealth Legal Education Association International Conference on Law and Technology held in Kumarakom, 17th and 18th of a guiding principle, we affirm that sustainability, including environmental, social, and economic aspects, must be the foundation for our development strategies in transport and tourism. We call for redefining ecotourism and explore regulation as both as facilitative and distributive justice. We stress the imperative of legal system to embed sustainability into their core framework, ensuring that regulation protect ecological balance, promote social equity, and support economic resilience. Secondly, need for a comprehensive regulatory framework and curriculum development for water transport. The emphasis, the urgent need for a comprehensive regulatory framework for water transport to ensure safety, efficiency, and sustainability. It also advocates for the development of special curriculum to equip legal professionals with the necessary expertise to address the complexities of water transport regulation, fostering innovation and the best practices in this crucial sector. It is also resolved that the legislation should be brought into the administer and water metro in Kerala and in other statute within the federal framework. Third, integration of technology with legal framework. We acknowledge the transformative impact of technological innovations in our fields. The autonomous vehicle to sustainable energy solutions and digital platform for ecotourism technology hold great promise. Fourthly, regulatory convergence and best practices. We argue the harmonization of legal framework across jurisdiction to facilitate seamless integration in transport and tourism, especially in cross-border contexts. Sharing the best practices and adoptive collaborative approaches among Commonwealth nations will strengthen our regulatory mechanism and address shared challenges effectively. Fifth, capacity building and empowerment of justice system. Enhancing the capacity of legal professionals, policymakers, and judicial system is essential to address the multifaceted challenges at the intersection of law, technology, and sustainability. We advocate for the integration of technology-driven tools within justice system to improve efficiency, transparency, and accountability. Sixthly, ethical consideration and social equity. We highlight the need for ethical consideration in our regulatory frameworks to promote inclusivity, protect human rights, and minimize environmental impact. Next is protection of responsible tourism. promotion of responsible tourism. Recognizing the importance of responsible tourism, we all for the legal policy framework, we call for the legal and policy framework that support ecotourism, engage local communities and conserve natural and cultural heritage. Seventh, advancement of legal education and future of law professionals. We recognize the necessity of evolving legal education to meet demands of a rapidly changing world. It calls for the integration of emerging technology, interdisciplinary approaches, and practical training to prepare law professionals for future challenges. The last, seventh, commitment to future collaboration. We pledge to continue collaborating with Commonwealth nation, academic institution and stakeholders to advance sustainable transport and tourism. If all of us agree for this, you can have the elaborate declaration and document will be sent to us. If you are accepting that, you can have. Thank you very much. This declaration represents our shared resolve to leverage law and technology in creating a sustainable and tourism. As delegates of this conference, we commit to advancing this principle for our respective fields and working together towards a just, equitable and sustainable world. I should lastly emphasize that in pursuit of progress, it is perseverance, not just innovation, that leads to success. Hence, the journey we have started today requires not only innovation, but also persistence in our efforts. In closing, I wish to express my deepest gratitude to each one of you, our guests, speakers, participants, organizers, and other media friends. I look forward to continue our dialogue and collaboration in the days ahead. Thank you once again. Have a wonderful evening ahead.
Thank you, sir, for your detailed report and the significant Kumarakom declaration, which will undoubtedly guide our future endeavors. Next, I have the privilege to invite Honorable Mr. Justice C.S. Dias, Judge of the High Court of Kerala and Co-Chairperson Organizing Committee, to provide an overview of the conference and share the way forward.
Honorable Mr. Justice B.R. Gawai, Honorable Justice Surya Kant, Honorable Chief Justice Mr. Ronnie Govindan, Honorable Chief Justices Vinod K. Chandran and Sunita K. Agrawal, my Acting Chief Justice Mr. Justice Mohammad Mustaq, respected Dr. R. Venkatramani, the Learned Attorney General of India, dear Professor Dr. S. Shivakumar, respected brother and sister judges from the various high courts of the country, and also respected judges from the Honorable Supreme Court of India, my judicial officers, members of the academia, legal scholars, eminent speakers, distinguished guests, and students. A very good afternoon to all of you. The Kumarakom Declaration, just made by Professor Shivakumar, is a watershed moment for our country and has really given life and meaning to the two-day CLEA International Conference. The various insights and suggestions that were discussed and made in the inaugural as well as the 4 brainstorming technical sessions should kindle the minds of all the stakeholders involved. I am reminded of Barack Obama's words, who said, "We are the first generation to have felt the effect of climate change and perhaps the last who can do something about it." It is to do something that all the distinguished speakers converged and participated and have spoken about it. When respected Justice Suryakant and Learned Attorney General finalized the conference subjects on sustainable developed transport, tourism, and technological innovations and chose the conference destination as Kumarakom, I felt that the subjects and the destination correlate and gel well, and the conference has begun well and is half done. I say this because recently the New York Times had included Kumarakom in the list of 52 destinations which is must-see tourist destinations. We have everything in Kumarakom. We have the Vembanad Lake, the largest lake in the country, one of the biggest bird sanctuaries, and the best freshwater fish in the world, that is the karimeen, and I am sure some of you who taste it will endorse my views on it. This is perhaps the reason why former Prime Minister of India, late Atal Bihari Vajpayee, chose Kumarakom as the destination to spend his 77th birthday and also for rejuvenation about 24 years back. When he left, he said, "No, now I know why Kerala is God's own country," and these words of his put Kumarakom in the world tourist map. And that is how the G20 conference was held recently there, and the political and the executive participated, and we followed suit with the judiciary in the CLEA conference. When it comes to sustainable transport, Kumarakom is the most ideal place. Full stop. Kumarakom is an ideal place. I fondly say so because it is the Venice of the East. We have about 2,500 houseboats which are there, and as you all must have seen, after 5:30, there is no boating permitted. You must have asked the reason why. It is to help the local fishermen of the islands surrounding the lakes who lay the gill nets across the lake, spreading from the districts of Kollam to the district of Ernakulam. This truly gives the meaning to sustainable transport and tourism. The words of the Learned Attorney General in the inaugural address had kindled my mind. That is, if you tinker with the mountains, it will reflect in the oceans. In other words, the ecosystem is all connected. That is what he said. Our state is known for the mining on the mountains, for the construction material in the valleys. Has it not resulted in the torrential rains, the unprecedented floods, and also the devastating landslides which we witnessed a few weeks back? I am reminded of the words of the father of the nation. He said, I quote, "Nature offers everything to satisfy human need, but it does not offer enough to satisfy human greed." I unquote. Earth is a fine place and it's worth fighting for it. It is to preserve the Mother Earth, its flora, fauna, and its natural resources. We have seen the Honorable Supreme Court and the High Courts in the country exercising environmental justice and equity jurisdiction to preserve our nation by laying normative guidelines where there are no statutory legislations. It's to preserve our country. The closing down of the industries around Taj Mahal is a classic example. In the realm of technological innovations, we are witnessing a revolution which is reshaping every aspect of our lives. We are in the 5G era. The ChatGPT founder himself is asking us to find ways and means to curb the explosion. Our journey through the conference themes has created many paths and put forward and sparked valuable discussions that we must transform into actionable steps. The theme of this conference is not just timely, but also is indispensable for our collective future. The convergence of these domains hold the key to addressing some of the most pressing issues of our time. As responsible citizens, our task is to ensure sustainable transport, tourism, and technological innovations. We must focus on translating our discussions into actionable outcomes. I encourage each one of you to engage in meaningful dialogue, to challenge the conventional thinking, and to explore new possibilities. I am honored and privileged to be part of the organizing team that has made this international conference a reality. I am extremely thankful to the chief patron and the patron for choosing God's own country as the venue, the birthplace of late Professor Madhava Menon, one of the founding pillars of CLEA. I express my sincere gratitude and thanks to all the eminent speakers and the distinguished guests and the participants for participating in the conference. With the permission of the chief patron and the patron, I would be failing in the duties if I don't thank the district judiciary as well as the district administration who have been running around for the last 1 month in organizing this event. I also place on record my special appreciation to Dr. Girishanga, who has been the secretary of the organizing committee and who has lost a few pounds, which is appreciated by his wife. We look forward to hosting you all again in God's own country. Thank you all for your participation and contribution. Thank you, Jai Hind.
Thank you, sir, for your comprehensive overview and for setting the direction for our continued efforts. It is now my honor to invite our esteemed patron, Dr. R. Venkataramani, Learned Attorney General for India, to address this august gathering.
What can a little bird I call CLEA can fly high and fly as big spaces as possible. Whenever India was given the opportunity of becoming the chair of CLEA, one foremost thought which came to our mind, which I shared with Justice Suryakant, being our chief patron, and he has been guiding us, giving us enormous time, as much as I would like to have from him. One of the foremost thoughts was, India had a G20. Now India is seen as a different figure in world global political, social and economic dimensions. And I keep thinking that as we move into the next phase of global human connectivities, the mantra is not what the colonial masters gave to us, that we are big brothers. The mantra is something very different. The mantra, I thought, should be equal regard of all, and with that equal regard, we get equal reward for all. I think this is what India is trying to demonstrate to the rest of the world. And if that's possible at the political executive level, I think it's important that the legal fraternity is able to slowly march along with it at the same pace, if not at a greater pace. And that's where CLEA, I thought, should be able to play its role. And I'm so happy that we have Justice Roni Govindan from Seychelles, which is this part of the globe to India, and we have the Attorney General from Fiji, which is the other part, and we have in between the learned judge from Malaysia. What a wonderful congregation of a global citizenship. I think we must build this global congregation of legal fraternity through all the endeavors, and I'm so happy that we're able to do this in a very small measure. I thank all the invitees who have come from very long places and travel long distances, and I know we have only scratched the surface of the subject. There's much more to be spoken about, much more to talk about, much more to reflect upon. But the idea is not to probably gather, do a 5-day cricket match, but to come in even a 2020 space, but to find out how close we are connected on global common concerns. And I know many speakers would have given us more insights and better reflections of their experiences. My apologies that we're not able to do that, but I'm sure that you go back with a great sense of comfort and feeling that India and the legal fraternity of India is able to show to the rest of the world what I may call a non-violent revolution through rule of law is possible. The subject we have picked up is a very important subject. We reflected on it for a long time, and I saw the connectivity as a subject with many aspects of our economic, social, and political dimensions. So when you talk of ecotourism, I think it's connected to everything about development, everything about economics, everything about social justice. So how do we go about doing that? So we have gathered wonderful insights in the past day and a half, and I'm sure if I have to put my notebook into a chat GPT and ask for probably a outcome on this, I would rather say, please wait, chat GPT. My mind and all the minds which are gathered here are far more engaged in the greater concerns of promoting human welfare on an equal regard and equal reward basis. And I consider this meeting today, though too small, but I think it's big in its effort, big in its understanding, and going to be huge in its impact. Small beginnings made, I suppose, but I think impacts are going to be huge. I was having a wonderful conversation with the Attorney General from Fiji. We are talking of Indo-Pacific, legal exchanges. We are talking of Indo-African legal exchanges. And recently when the ambassador from Argentina came to meet me at my home, they're talking of Indo-South American global legal exchanges. What a wonderful thing to be part of this global exchange program. I don't want to say anything more. I feel very happy that as part of the congregation, I've been able to reach out to each and every one of you. We'll keep reaching out to each and every one of you and as many times as possible. And I thank Justice Gawai for being with us here today, encouraging us, and Justice Suryakant for being the chief co-patron, and all the others who worked for this conference tirelessly. Thank each and every one of you. And I only end by saying, sometimes you feel very emotional about certain things. But today morning, this is a beautiful place. I come to Kerala very often. A lot of Kerala connections in my life. There's Krishnagiri, the foremost Kerala connection. So when I sat in the morning near the lake, some thoughts came into my mind, and I thought, let me pen them down, and I hope, with your permission, I can read it. Whether it resonates with the conference or not, I have no idea. But on the bank of the lake at Gokulam, water spread as thin sheet, withdrawn in its innermost moments, as if in secret initiation, kept close to its chest, winding up my thoughts, I sit by your laps of silence, eyes not seeing, limbs locked to rest, the restless pumping heart asked to chant holy words, in love and beauty drawn, nothing to be asked, nothing to be stored, nothing to be sought, nothing to be fought, nothing to be kept, as treasures not to be spared. No wish or desire killing, no wish to be in longings locked. Wind and water in quiet embrace is a mantra of a special sort. The greens of many ways, in splendid meditations, in joyful mirth of their creation. Why do, in wasteful chase of things and matters of teasing means, we make no sense? Thank you for your attention. Thank you for everybody coming here.
Thank you, sir, for your insightful address and for the invaluable guidance you have provided throughout this conference. We are privileged to have with us Honorable Mr. Justice Suryakant, Judge, Supreme Court of India and Chief Patron of CLEA, to deliver the presidential address.
Chief guest of the event, Honorable Mr. Justice B.R. Gawai, Judge, Supreme Court of India, Justice Roni Govindan, Honorable Chief Justice, Republic of Seychelles, a team of my esteemed colleagues from Supreme Court of India, led by Justice Nasima, who is present here, Justice Nalini Padmanathan from Federal Court of Malaysia, Justice Surya Raju, Judge from Sri Lanka, Supreme Court, Justice Anil Sinha, Supreme Court Judge from Nepal. Our Chief Justice, two Honorable Chief Justices are with us beside the Acting Chief Justice, and who has really acted very well in this conference. Justice Sunita Agarwal is with us, Justice Vinod Chandran from Patna High Court and Gujarat High Court both. Acting Chief Justice Muhammad Mustaq. Learned Attorney General, you have seen that our distinguished Attorney General wears many hats. He is a great poet. In fact, already books also published, and well, today again he has demonstrated. Justice C.S. Dias, Judge on High Court of Kerala, very distinguished judges from different high courts who have come all the way to participate in this conference. Mr. Loknath Behra, Managing Director, Kochi Metro Rail Limited. Dr. Giri Shankar, Secretary of the Conference Organizing Committee. Professor Dr. Shiva Kumar, President of the Commonwealth Legal Education Association. Learned Solicitor General probably might have gone, but we have among us Madam Aishwarya Bhatti, Learned Additional Solicitor General of India is here. the President of the Commonwealth Lawyers Association, Mr. Santhanan Krishnan, Mr. Guru Krishna Kumar, Senior Advocate. We have a very distinguished domain expert between us, Mr. Jay Chima. He has authored a very wonderful book, Justice Narasimha, and we both had occasion at the time of release of that book. Many other members of the bar who have come all the way to join us in this conference were the vice chancellors of various universities within and outside the country. Many jurists are also here. Dear delegates and my dear students, a very good afternoon to all of you, and thank you very much for joining us in this conference. Being the chief patron of the Commonwealth Legal Education Association, and for this conference I have the honor to witness the collective efforts and insightful deliberations that have unfolded over the last 2 days. In some of the sessions I couldn't attend, but I used to get the feedback, and a very good insight of that, the deliberations, the discussions which took place in the conference, Justice Dias has already very well explained to you, and those are also reflected in the resolution that has been passed, which Professor Sivakumar read out. I extend my heartfelt gratitude to each one of you for your active participation and insightful contributions to the cause of justice. The success of this conference is a result of the collaborative efforts of all those present here. As we come closer to this 2-day journey, I want all of us to reflect on the timeless saying, and I quote, "The wisdom shared in the today will pave the path for the breakthroughs of the future." Over the past 2 days, we have collectively sown the seeds of insight and innovation, and it is these very seeds that will bloom into solutions to address the challenges of tomorrow. This conference was convened with the purpose of ignite meaningful dialogue and foster collaboration among stakeholders from various fields. In addition to the insights gained, we have emphasized the importance of resilience and capacity building. The challenges we face today require not only innovative solutions, but also the strength to adapt and evolve in the face of adversity. I am happy that CLEA as an organization is working relentless to build platforms for dialogue and collaboration, which have been instrumental in advancing legal education and addressing global legal challenges. The previous achievement of CLEA, some of you might have participated in the Attorney General and Solicitor General Conference in 2024. I am quite happy, and I believe this conference too shall illuminate the path forward with clarity and purpose, from developing robust legal and ethical framework for sustainable transport and ecotourism to navigating the regulatory challenges posed by innovative technologies. We have charted a course for progress. The discussions reflected a collective commitment to addressing these issues with foresight and responsibility. We have also explored the urgent need for comprehensive legislative reforms to meet the challenges posed by emerging technologies and sustainable practices. The discussions in sessions on unified transport laws or integration of AI into regulatory frameworks has made us to rethink a course towards the future. I am quite happy that the very healthy and very deep insight discussions took place, and we have been able to way forward to certain solutions which will really go a long way in resolving the issues which we perceive as the future challenges. Several recommendations have emerged, including developing comprehensive case management framework that outline best practices, guidelines, and procedures. These frameworks should be adaptable to the specific needs and contexts of different legal systems. In addition to these measures, investing in training and capacity building of judges, court staff, and legal practitioners can also help ensure that all stakeholders are equipped with the skills and knowledge needed to implement practices. As the oft-quoted saying goes, and I quote, "The journey of 1,000 miles begins with a single step." As we reflect on the knowledge shared and the discussions held, it's clear that our journey has been both challenging and promising. The innovations and legal frameworks we have deliberated upon will shape the future of sustainable transport, ecotourism, and justice delivery. It is our shared responsibility to translate these discussions into actionable strategies and policies that will drive meaningful change. I suggest that as we return to our respectable roles and responsibilities, we continue to build on the momentum generated here. Let us take the insights and strategies we have developed and transform into actionable plans. The journey is ongoing, and with CLEA's continued support and by the collective efforts of legal luminaries, scholars, and practitioners, we are well positioned to address the challenges that lie ahead and shape a legal framework that reflects our shared values of fairness, equality, and justice. In closing, I wish to once again express my deepest gratitude to each one of you, our guests, speakers, participants, organizations, dear students, and above all my dear friends. Thank you very much. Thank you.
Thank you, Justice, for your inspiring words and for your unwavering support to CLEA and its mission. I now have the pleasure of inviting Honorable Justice Mr. Ronnie Govindan, Chief Justice of the Republic of Seychelles, to deliver the congratulatory address.
Excellencies, distinguished guests, participants, dear colleagues, ladies and gentlemen, I would like to congratulate all of us for making the Commonwealth Legal Education Association, the CLEA's International Conference on Law, Technology, Sustainable Transport, Tourism, Technology, Innovations, a resounding success. As I mentioned in my opening remarks, this is the very first time that I had the opportunity to attend a CLEA's meeting. After having immersed myself in this experience, I emerged with a renewed sense of enthusiasm, feeling this experience. I am of the vision that is, I'm sure, shared by you, that it takes such kind of assemblies for this kind of experience to be revealed. I am happy to see the impressive spirit of cooperation and the passion to make a positive change which animates all of our sessions and endeavors. This accompanied us throughout our discussion in all the themes that we discussed about. One strong theme that I have seen throughout these 2 days is the need of making ecotourism relevant to our local communities and how this should be achieved both at a national level and at a state level. Just as I am sure you will do when it comes to your different functions, I am also taking back to Seychelles brilliant, innovative ideas learned in this conference, especially in this aspect, for as you know, Seychelles is a very strong tourism-oriented republic. I would like to congratulate the organizers. Special remarks goes to the government of India and the beautiful state of Kerala and the judiciary of Kerala for hosting our works in such a generous and very pleasant way. To the CLEA, it is my view that you have chosen, you could not have chosen a better team in terms of its relevancy to our developing economies and in terms of the emerging trends of technology on national development and the law. I would like also to thank the chair of the organizing committee, Mr. Justice Mohammed, Acting Chief Justice of the High Court of Kerala, and other members of the organizing committee and resource persons. When I first came to look at the subjects of this conference, law, technology, sustainable transport, and tourism, I must admit that I was a bit muddled. What a mix, I told myself. After these few days, however, I could see a common thread that was wove and is weaving through these 4 words. The interreliability and commonalities is very now much obvious. It is sustainability, and this has been clearly shown. A big applause also goes to the Honorable Attorney General, the Justices of the Supreme Court, the Judges of the High Court of India, and the Chief Justices assembled, and also the other dignitaries and judges from abroad. We all have left our important responsibilities and duties, and we have met here selflessly in order to discuss a very humane theme, which includes, amongst others, the environment in order to preserve it for ourselves and our future. In the words of one contributor, which still remains with me, is that we take stock, that we are all here temporary. We are temporary tourists on a temporary tourist permit here. And the earth is our fragile and only destination. We don't have anything else besides this. I would like to congratulate each and every one of us, speakers and discussants. The level of the different presentations were at the very highest. I could see that the qualities of the papers showed that it took great efforts, dedications, and skills to put them together. Indeed, we go away feeling very enlightened from what we have experienced, and we will surely seek to apply these best practices in our respective jurisdictions and in law, tourism, and technology. I congratulate all attendees for their attendance and their great sense of attentiveness and for keeping at all times to the schedules. It is my wish that we continue to keep the network that we have established and that we have created here. And we establish a platform for cooperation with each other as we take necessary steps to put the final declaration that we have just heard. My departing words are as follows. Human needs are infinite. Natural resources are finite. The question is, how do we best limit the former in the interest of the latter? When circumstances call for us to take a decision and to say no to development, we need to have courage and say no. When we need to say yes, we say yes. When we need to say yes, but there are certain conditions, we apply those conditions, and we keep monitoring and ensuring that there's good outcomes. And we have seen those best practices here when it comes to technological developments, case management, which I finally saw that it also impacts sustainable tourism and different form of developments. I am sure that just as I, you are looking forward to hear more about the implementations of the outcomes of this meeting and the declaration. And as a follow-up, maybe we can also share our personal experience in the various fields that we have encountered here and challenges and achievements in our respective jurisdiction. And we can also use CLEA as a platform for dissemination of those outcomes. Finally, I wish to wish you all well, bon voyage back home, and let us keep and cherish these fine memories for a long time to come. Thank you.
Thank you, sir, for your kind and encouraging words. To mark the conclusion of this esteemed conference, it is my great honor to invite our chief guest, Honorable Mr. Justice B.R. Gawai, Judge, Supreme Court of India, to deliver the valedictory address.
A very good afternoon to everyone. Honorable Justice Roni Govindan, the Chief Justice of the Republic of Seychelles, my esteemed colleague, Justice Suryakant, the Chief Patron of CLEA, my esteemed colleague Justice Narsiva, Justice Mohammad Mushtaq, the learned Acting Chief Justice of the High Court of Kerala, Srimati Sunita Agarwal, the Chief Justice of Gujarat, Justice Vinod Chandran, Chief Justice of Patna, Dr. R. Venkatramani, the learned Attorney General of India, Justice C.S. Dias, the Judge of the High Court of Kerala and the Co-Chairman of the Organizing Committee, my learned colleagues present from the other jurisdictions, Justice Nalini Padmanabhan, Justice Surya Raju, Justice Anil Kumar Sinha, the brother and sister judges from the different high courts present here, Srimati Aishwarya Bhatti, the learned Additional Solicitor General of India, the Vice Chancellors of the different national law universities, the other universities, the faculty members and the academicians, the learned senior lawyers and the other members of the bar, the colleagues from the district judiciary, the Registrar General and the other registrars of the High Court, and dear students, and of course, Professor Dr. Shiv Kumar, who has been behind this conference for last so many months, Mr. Loknath Behra, the Managing Director of the Kochi Metro Rail Limited, who has played a role of a perfect host, Dr. Girishankar, the Principal of the St. Dominic College of Law, and friends. Thank you very much for having me here to deliver the valedictory address of this important conference, delving into the interplay of law, technology, sustainable transport, and ecotourism. Over the past 2 days, we had thought-provoking deliberations on the legal implications of the integration of emerging technologies in sustainable transport and tourism. Technology surely boosts remarkable improvements in efficiency, accessibility, and environmental stewardship. Yet, we also grappled with the complexities and uncertainties that these advancements bring, particularly in terms of regulation, privacy, and ethical considerations. This conference offered an excellent opportunity to engage in meaningful discussions on various themes and share insights on how we can harmonize legal structures with technological progress to achieve a more sustainable future. Transport and tourism are two key sectors driving developments countrywide and specifically in India. They play a vital role in national progress by providing significant employment opportunities, contributing to the national GDP, enhancing community engagement, and fostering regional cooperation. As we face unprecedented challenges due to climate change, environmental conservation has become indispensable. Development and ecology are both integral to human rights and the growth of the country. The courts are often called upon to resolve the conflict between the conservation of the environment and development in the larger interest of the nation. The outdated notion that development and environmental preservation are mutually exclusive is no longer tenable. Sustainable development offers a solution. The Supreme Court, while considering the issue relating to environmental protection arising out of the construction of Tehri Dam, in the case of ND Jail versus Union of India, observed, and I quote, "The balance between environmental protection and developmental activity could only be maintained by strictly following the principle of sustainable development. This is a development strategy that caters to the needs of the present without negotiating the ability of the upcoming generations to satisfy their needs. It is a guarantee to the present and a bequest to the future." Consequently, the tourism and transportation industry is transforming to adopt sustainable practices that are ecologically sensitive. The adoption of sustainable transport and ecotourism aims at a balance of preserving natural landscapes and biodiversity and ensuring that tourism continues to offer enriching experience to the people. Initially, understanding the current landscape is essential. Environmental protection regulations that were enacted with the aim of preserving natural habitats and biodiversity are now made applicable in promoting ecotourism. For example, the amended Wildlife Protection Act of 1972 establishes a tiger conservation foundation that shall promote ecotourism with the involvement of the local stakeholders and provide support to safeguard and natural environment in the tiger reserves. The Supreme Court has echoed the necessity to adopt ecotourism recently in one of the orders that this court passed in the case of T.N. Godavaranam. It directed the Ministry of Environment, Forest and Climate Change to appoint a committee that shall consider and recommend the types of activities that should be permitted and prohibited in the buffer zones and fringe areas of the tiger reserve. It has been further directed that while doing so, it is directed that if tourism is to be promoted, it has to be ecotourism. The type of construction that should be permissible or restrictions that should be imposed must be with the object of protecting and maintaining the natural environment. Further, in the case of MC Mehta versus Kamal Nath, the Supreme Court had issued a show cause notice for exemplary damages against a motel for interfering with the natural flow of the river and thus disturbing the environment and ecology of the area. While upholding the application of the public trust doctrine, the court explained that the public is the beneficiary of the natural resources that are meant for public use and cannot be converted into private ownership. Likewise, in another instance, the Supreme Court vacated the order of the Bombay High Court, which permitted the lease for setting up a snack bar and restaurant to cater to the needs of visiting tourists in the resort forest and stressed the necessity of protection of environment and preservation of forest wealth. Adopting ecotourism needs in transportation laws involves enhancing public transport efficiency, setting emission standards, switching to energy efficient fuels, incentivizing green technologies, transitioning to electric and hybrid vehicles, developing sustainable transportation infrastructure, and harmonizing regulations to address issues like excessive tourism. Earlier, taking into cognizance the growing menace of air population, the Supreme Court had directed the Transport Department of Delhi NCR to announce that all diesel vehicles more than 10 years old and petrol vehicles more than 15 years old shall not ply in terms of the order of the National Green Tribunal of 2015. Further, in one of the public interest litigations pending before the Supreme Court, seeking directions for the promotion and implementations of the recommendation of electric vehicle policies, the Supreme Court has taken a cognizance of the importance of issues pertaining to the source of the power of vehicles on the environment in the country, and has sought information of all the policy decisions taken by the central government from time to time to promote electrical vehicles. The existing framework sometimes fails to address phase-wise improvements effectively. So we must identify new approaches. Certain areas in the regulatory framework need legislative and executive deliberations, and such as setting vehicle emission standards and ensuring that infrastructure development aligns with environmental and safety standards. Regulations need to address the gaps in regulatory mechanism and adapt to the complexities introduced by emerging technologies. The infusion of technology in these sectors gives impetus to eco-friendly practices that promote sustainable goals. The adoption of emerging technologies such as machine learning, artificial intelligence, and blockchain facilities, the use of data-driven transportation systems, GPS-based tracking systems, smart traffic management systems, remote sensing, virtual tours, interactive maps, and so on. These tools not only enhance accessibility, affordability, and outreach, but also promote a sustainable future. Significantly, the use of machine learning and algorithms in predicting traffic congestion and managing routes is highlighted. AI in transport holds promise for improving travel experiences through real-time data and intelligent systems. Some state governments have deployed an AI initiative known as the Intelligence Traffic Management System. The project involves AI-enabled cameras that assist the state authorities with security, detecting traffic violations, and issuing e-challans through SMS on the mobile phones. Further, in some countries, it is being discussed whether to employ AI in developing automatic vehicles that navigate independently and enhance sustainability in public transportation. AI's ability to optimize fuel consumption, reduce emissions, and improve accessibility by targeting high-demand areas reflects its transformative impact. Building effective AI solutions requires vast amounts of data and experience, which currently limits their accessibility and makes them costly. However, integrating these technologies into transportation and tourism presents complex legal and ethical challenges. It necessitates a thorough examination of current regulations and potential risks. Current legal framework are fragmented and inadequate to manage the expanding and evolving ecotourism sector. Particularly, digitization and emerging technologies deal with a vast amount of citizens' data, which raises concerns about data privacy and cyber security. The service providers, including the government and companies, must have a foolproof mechanism detailing privacy and security procedures. Moreover, we do not have a legislative or judicial answer to who owns the liability on account of decision-making in AI-driven devices like autonomous vehicles, whenever they are permitted. These are certain issues that are still unanswered and require stakeholder discussions and legislative interventions. Further innovations in transportation, including water metros and robotic machines in other countries, have outpaced existing laws. Technologies like autonomous vessels and advanced navigation systems can boost the efficiency and safety of water transport while minimizing environmental impacts. While developing cross-border transport corridors and integrating renewable energy is a way ahead, addressing inconsistencies and harmonizing international transportation regulations to address infrastructure development and border security is a first step. The approach offers countries sharing ecosystems a pathway to regional stability and economic prosperity, provided that legal frameworks, capacity building, and stakeholder cooperations are carefully managed. The session on collaborative approaches and best practices has equipped us with the knowledge to develop comprehensive strategies that balance technological innovations with ethical and environmental considerations while promoting cross-border transport initiatives. The holistic integration of ecotourism and transportation law requires capacity building, community involvement, technological advancements, sharing of best practices, and monitoring and evaluation. Capacity building for legal professionals involves continuous legal training and interdisciplinary education to ensure effective and ethical use of technology. With the ongoing technological advancements, even the legal system is transforming to create a more efficient, transparent, and accessible justice system. In the last decade, the Indian judiciary has actively engaged with technology to scale up justice delivery system. The Supreme Court has proactively implemented technology-adept initiatives, including e-court projects, online hearings, live streaming of hearings, e-filing systems, and so on. These initiatives have further enabled the judicial system to effectively try, evaluate, and implement various softwares and applications such as e-payment, case management systems, the National Judicial Data Grid, and the National Service and tracking of electronic processes. Moreover, the Supreme Court is capacity building by organizing continuous training programs for judges, lawyers, and court staff to accustom them to the digital transformation. Significantly, the Supreme Court is using AI technology in the translation of judgments into vernacular languages, legal research and process automation in case tracking and case flow management. In environmental and transport cases, AI tools can be used to track numerical data such as rates and fees paid, required to be paid during the grant of license, permits, and so on. While technology has the potential to improve access to justice, the judicial system has to consider the ethical implications of technological advancements, especially in a diverse country like India, where demographic and social divides add layers of complexities. After the engaging discussions at the various sessions held in the conference, I conclude that balancing the benefit of responsible tourism with environmental impact remains challenging. Addressing these challenges involves harmonizing international regulations, fostering community engagements, and developing sustainable practices. We require a legal system that can accommodate the unforeseen legal issues arising out of emerging technologies and balance the competing interests of various stakeholders involved. As we move forward from the conference, I urge each of you to take the insights and strategies we have explored and apply them within your spheres of influence. The Kumarakom Declaration, which was read by Professor Shiv Kumar and adopted by all of us today, will go a long way in striking out a balance between a development of tourism and transportation on one hand and protection of environment on the other hand. The path ahead will require continuous collaboration, innovation, and vigilance. Our goal is not just to witness change, but to shape it actively. Let us continue to work together to navigate the evolving landscape of law and technology, ever mindful of our shared responsibility to guide these advancements that are sustainable, inclusive, and just. I look forward to the continued progress and collaboration that lies ahead. Thank you very much.
Thank you, Justice, for your profound and closing remarks that will resonate with us as we move forward. May I now request Professor Dr. Lisa P. Lucas, Professor, University School of Law and Legal Studies, Director, Legal Aid, and Secretary, CLEA Asia, to announce the felicitations.
As a token of the profound respect and gratitude we hold for our esteemed guest, may I request Dr. R. Venkatramani, Learned Attorney General for India and Patron CLEA, and Professor S. Shivakumar, President CLEA, to felicitate Chief Guest of the Day, Honorable Mr. Justice B.R. Gawai, Judge, Supreme Court of India. Yes, please. This is from Tamil Nadu, sir. Yesterday's was the Kerala traditional Ponnada. This is different. Thank you, sir, for kindly accepting our honor. May I request them to honor Honorable Mr. Justice Roni Govindan, Chief Justice of the Republic of Seychelles. Thank you, sir. May I request them again to honor Honorable Mr. Justice Suryakant, Judge, Supreme Court of India and Chief Patron of CLEA. Now, may I request, sir, may I proceed? Now, may I request Honorable Mr. Justice B.R. Gawai and Honorable Mr. Justice Suryakant to felicitate Dr. R. Venkatramani, Learned Attorney General for India and Patron CLEA. Yes, sir, please. Thank you, Honorable Justices.
There will be a vote of thanks, but I was listening to the speeches by Ms. Gawai and Suryakant. We all talk about the 1972 Stockholm Declaration. Phonetically, Kumarakom and Stockholm are something common. I think in times to come, it will be Kumarakom Declaration and not necessarily Stockholm.
May I request Honorable Justice P.S. Narasimha, Judge, Supreme Court of India, to kindly come over to the stage and receive the honors of the day. Kindly please come on to the stage, sir. And may I request Honorable Justices of the Supreme Court, Honorable Justice B.R. Gawai, sir, and Surikant, sir, to kindly honor him. Kindly come on to the stage, sir. May I request Honorable Justice Nalini Padmanabhan to kindly come out to the stage and kindly accept our honors. May I request Honorable Justice Gawai and Honorable Mr. Justice Surikant to kindly honor Madam. May I request Honorable Justice S. Suri Raja, Judge, Supreme Court of Sri Lanka, to come out to the stage and kindly accept our honors. May I request Mr. Graham, Attorney General of Fiji, to kindly come over to the stage and receive our honors. May I kindly request Honorable Mrs. Justice Sunita Agarwal, Chief Justice of Gujarat, to kindly come over to the stage and kindly accept our honors. പുറത്തേക്ക് പോയി. May I request Madam Aishwarya Bhatti, Additional Solicitor General of India, to kindly come on to the stage and receive the honors of the day. Thank you, Honorable Justices B.R. Gawai, sir, and Surikant, sir. It was such a thought-provoking, and this shows how generous and gracious you are. Thanks a lot. Now we will proceed with the other felicitations of the day. I will request now Honorable the Learned Attorney General of India and Professor Shivakumar to honor Honorable Mr. Justice Muhammad Mustaq A, Acting Chief Justice, High Court of Kerala. Sir, kindly come forward, sir. We request both the Honorable Lordships to join. And may I request them to felicitate Honorable Mr. Justice C.S. Dias, Judge, High Court of Kerala, and the Co-Chairperson, Conference Organizing Committee. May I request them to again honor Mr. Lokanath Behra, Managing Director, Kochi Metro Rail Limited, and co-chairperson Organizing Committee of the conference. May I request May I request Honorable Mr. Justice B.R. Gawai and Honorable Mr. Justice Surikant to felicitate Professor Girish Shankar SS, Secretary, Conference Organizing Committee, who has been working tirelessly for months together to the meticulous execution of the conference. Kindly give him a big applause. May I request Honorable Mr. Justice B.R. Gawai and Honorable Mr. Justice Suryakant to felicitate Professor S. Shivakumar, President CLEA, who has been the mastermind of this conference and whose careful efforts made this conference a successful outcome. Please give him a big applause. Thank you, Honorable Judges. Thanks.
As we approach the conclusion of this valedictory session, it is my privilege to invite Dr. Girish Shankar SS, Principal of St. Dominic's College of Law, Kanjirapalli, and Secretary Organizing Committee to deliver the vote of thanks.
Good evening, one and all. Respected Honorable Mr. Justice B.R. Gawai, Honorable Mr. Justice Suryakant, Honorable Mr. Justice Roni Govindan, Honorable Justice Mushtaq Sir, Honorable Justice Dayasal, Mr. Shivakumar, Learned Attorney General Dr. Venkatramani, Mr. Loknath Behra, and all other honorable judges, other dignitaries of the dais. Let me at the outset tell you that I am not so conversant about the Loknath Behra magic of rolling it in one sentence, because it's the formal vote of thanks after the culmination of a historic international conference. Ladies and gentlemen, I stand before you with excitement and contentment at Kumarakom, which is situated in the pristine lap of the majestic Vembanad Lake, which is a home for multitudes of people and flora and fauna of the vast geographical terrain. The CLEA International Conference has put Kumarakom again in the international world map, because when we were pondering over the possibilities of raising regulatory regimes in the evolving terrains of the engagement of technology, particularly in the niche areas of transport and tourism, besides deliberating on the need to strengthen the capacity of justice delivery systems while engaging technology. Every learning happens in continuum, and an auditing of the deliberations here reflect the areas that we have tread and the ones remain to be comprehended. Let me just pass on to my duty of thanking each and everyone who have graced this occasion. The CLEA, in fact, profusely thank Honorable Mr. Justice B.R. Gawai, Judge, Supreme Court of India, who have graced this occasion, not only in this valedictory ceremony, but he was all along our academic exercise and gave us significant inputs. In this august occasion, CLEA places on record its profuse thanks to Honorable Mr. Justice B.R. Gawai. Thank you, sir, for attending. Next, it is with proud privilege, CLEA again, it's thank profusely Honorable Mr. Justice Suryakant, Judge, Supreme Court of India, as well as patron CLEA, under whose patronage the idea of holding this conference germinated and then evolved and materialized in these 2 days at this place. Sir, the Commonwealth Legal Education Association, which you lead, is profusely thankful to you for all the support and your indulgence in materializing this idea. Honorable Mr. Justice Roni Govindan, Chief Justice of the Republic of Seychelles, came all the way from his country. Particularly, he said that how the perspective got changed when he attended all the sessions. Thank you, sir, for your frank and genuine comments. And the Commonwealth Legal Education Association places on record its thanks for gracing this occasion, and also you were there as a keynote speaker in the first technical session. Thank you, sir. We have got Dr. Venkatramani. I don't know in what way I can thank on behalf of CLEA, because his writ, or rather he had been there, his large presence was there ever since this idea was sown, then in its germination and its further branching out. And he had given us the courage to tide over many adversities that came in our way, and his patronage was singularly important for us in holding this conference and materializing this, the ideas. Sir, we are profoundly thankful for your great patronage and your indulgence, your support, love, affection, everything, sir. We have we have Acting Justice, Honorable Justice Mushtaq sir, who led us from front, who was the chairman of the organizing committee, and I don't know, innumerable meetings we had been holding ever since this organizing committee took shape. And every department he has led us. There weren't any hiccups there in any department or rather any organizational layers, and he held us together, and it was his leadership that saw us through many adversities. Sir, the Commonwealth Legal Education Association is grateful for your visionary leadership and your patronage, which had materialized in holding this conference. The organization, KMRL, in fact, was a sibling organization as far as CLEA is concerned, was a sibling of CLEA when it came to organizing the activities of this conference, multi-layered activities of this conference. Whenever we felt some strain, we leaned on to his broad shoulders, and he kept us going with his impeccable organizational abilities. So words fail to thank your leadership, and CLEA places its thanks to Mr. Loknath Behra. Mr. Shivakumar needs no introduction. His name is synonymous with Commonwealth Legal Education Association. When Commonwealth Legal Education, when India got the presidency in this year, and when Shivakumar was elected, that was a watershed moment for this organization, because in the short period itself, we had got momentous occasions, and in the days to come, CLEA will be creating an impact across the Commonwealth in ever so many ways, intervening into so many areas to create demonstrable outcomes. His leadership, his abilities, organizational abilities, infinite organizational abilities are all instrumental. And for formality, let me place on record a profound thanks on behalf of the Commonwealth Legal Education Association. Dr. C.S., Honorable Mr. Justice C.S. Dias again, worked with, he is a co-chairperson of the organization committee, along with Honorable Justice Mushtaq sir. He was also instrumental in visiting places. I don't know how many times we visited Kumarakom to find adequate spaces for accommodating the guests as well as the delegates, and then making again reconnaissance, again reviews, etc., etc. So because of his untiring efforts, we were able to stitch together things, and it is the privilege of the Commonwealth Legal Education Association to place in record a gratitude to his untiring efforts in holding this conference. I'll quickly pass through expressing gratitude, because this is the final moment of this conference where we cannot spare any person. So the animated presence of the Honorable Supreme Court judges has indeed set the tone and tenor for this intellectual exercise. So their resourcefulness were so contagious that it illuminated every corner of this conference and distinctly raised the levels of the deliberations. CLEA profusely thank Honorable Mr. Justice C.T. Ravikumar, Honorable Mr. Justice P.S. Narasimha, Honorable Mr. Justice Dipankar Datta, Honorable Mr. Justice Manoj Mishra, Honorable Mr. Justice Prashant Kumar Mishra, Honorable Mr. Justice Arvind Kumar, and Honorable Mr. Justice N. Koteshwar Singh for their invaluable presence, for engaging thought process, and for providing nuanced understanding of the topics we have discussed. We had with us judges across jurisdictions, particularly Honorable Justice Tan Sri Datta Nalini Padmanathan, Judge Federal Court of Malaysia, Honorable Justice Turai Raja, Judge of Supreme Court of Sri Lanka, and former Judge of Supreme Court of Sri Lanka, Mr. Justice Anil Kumar Sinha. CLEA sincerely thank each of the Honorable Judges for finding time to come over and for enriching the outcomes of this conference. Thank you, sirs, and thank you, madam. The presence of Honorable Mr. Justice Vinod Chandran, High Court of Chief Justice of the High Court of Patna, Honorable Madam Justice Sunita Agarwal, Chief Justice of Gujarat, who have graced the occasion and CLEA place in record sincere gratitude on behalf of this conference. The learned Solicitor General of India, Advocate Tushar Mehta, was with us all along our exercise, and his forceful and persuasive inputs will always be a guiding spirit for us. Thank you, sir, for attending this conference and being a guiding spirit. The vibrant presence of Srimati Aishwarya Bhati, learned Additional Solicitor General of India to Supreme Court, in different capacities in this conference was so enriching. CLEA is having that privilege to sincerely thank Madam Bhati. There were High Court judges from High Courts across the country, which demonstrates how the judiciary has approached this endeavor. The perspective reflected by these honorable judges will go a long way in evolving and fine-tuning the strands of thoughts into decipherable frameworks ready for application. I sincerely thank on behalf of CLEA all the High Court judges who have participated in this conference at various levels. All the speakers and discussants who provided us with cutting-edge knowledge and information so as to be processed by the legal fraternity. I thank all of you on behalf of CLEA. Academic delegates are sizable in number. 1/3 of the delegates belong to academic, including teachers and students. I thank each one of them who have contributed, who have really enriched the content of the academic discourses by doing researches. And please scan through the QR code in your badges, where you can find a massive information repository which will stand us in good stead in the follow-up conferences now onwards. Thank you, all these all the teachers, students, research scholars, especially the volunteer researchers from Government Law College Ernakulam, which is a public educational institution celebrating 150 years of its inception. I thank specifically because they have shouldered lots of responsibilities and they have amiably discharged those responsibilities. KMRL team led by Loknath Barasar, Shaji Janardhanan, the Chief General Manager of the Water Metro, Mr. Srijit, Sandra, Sajid, Sumi, Jayashankar and Ajit, they worked like each one of us, and they were shoulder to shoulder working with us everywhere. So KMRL, in fact, without the support, active support of the KMRL team, we would not have reached anywhere in holding this conference. Thank you, KMRL team. The advisory committee, again, organizational committee was led by Mushtaq sir. Advisory committee was led by Honorable Mr. Justice Jayashankaran Nambiar sir, and comprising of other dignitaries. And sir has also contributed substantially in adding, giving value addition to this conference at all levels. So thank you, Justice Nambiar sir. I should thank Government of India for all the help done of political clearances and all other things, and also Government of Kerala for wholehearted support in organizing this conference. As part of that, State Protocol Department, then the Police Department led by the Additional Director General of Police, M.R. Ajit Kumar, and his team, Mr. Karthik, who is the District Police Chief in Kottayam, and all his team members, maybe numbering into hundreds, might have toiled hard during these 3 or 4 days, or even before. So a big salute to the police team. Along with that, District Revenue Administration led by the Collector, Additional District Magistrate, and Sub-Collector, District Judiciary led by Madam Mini Das, who is the Principal District Judge of Kottayam, and all of the judicial officers, Fire and Rescue Services, Health, Irrigation, PWD, and Kerala State Electricity Board. A big salute to all of you, because without which this conference would have not been materialized. The event managers, rainmakers, the houseboat owners, etc., and also the KTDC and Gokulam and other properties for hospitality. And finally, to the CLEA team, who had flown in from Delhi, who have been there for many months, who have been toiling hard, and who have been making things work in so many, at so many levels. Let me just only read out their name. Of course, the higher level has already been comprehended. Let me come to the other persons. Vice President Dr. Joe Silva, General Secretary Srimati Meera Furtado, Joint Secretary Ruchi Sharma. I think a wonderful round of applause she needs. She might have contacted every single office of the judges time and again and coordinated everything. Then South Asian representative Professor A. Kumaralingam, Bangladesh, person representing Bangladesh, Barrister Prashant Barwas, who was with us in different capacities, Dr. Vikram Singh Arya, then Rajiv Amarasuriya. Then CLEA Asia Student Chapter, Mr. Salman Khasmi, who has been working tirelessly with other persons. Vice President Ayuba Mani, Advocate Ayuba Mani, then Secretary Lisa P. Locos, who has got an uncanny ability of leading things and making things happen, particularly when there is some pressure. Joint Secretary Ms. Amita Patil, and Executive Members Dr. Kokila Gonasinghe and Dr. Jijimohan V.S. We have got other persons as well, Nabila and Vasudha Bali. Yes. So the list goes like that. So, ladies and gentlemen, this has been achieved because of the synergy created at various levels, and this conference will stand out, as our learned Attorney General said, that it will be read above the UN Conference on Human Development that was there in 1972. And one thing alone, we will, I think, when we sign off, that we have to ensure that there should be some follow-up conferences where the human phase of technology need to be explored further, and the connectivity should also be there. And I am sure that CLEA will be engaged in all of that. So thank you all the dignitaries, delegates who have attended these days. Thank you.
Ladies and gentlemen, this concludes the valedictory ceremony of our conference. As we part ways, let us carry forward the insights gained and connections made. May I kindly request everyone to proceed for the tea. Thank you and have a wonderful evening ahead. Thank you all.
Before that, before leaving, I think we have got Honorable Justice Suryakant sir and Gavai sir, who will be interested in a very short interaction with the students okay. Okay, sir. So that will be a defining moment as far as this conference is concerned, because the academic delegates as well as students, they are really craving for. Okay. Yes. So I would request our learned Attorney General also to join this session for 5 or 10 minutes, just to have an interface which will help them a lot, which will give them a. Please come forward. Students, teachers who would like to.
अच्छा उनको बोल दो सर नहीं जा रहे क्योंकि वो टाइम हो गया, वो नहीं कर पाएंगे स्टूडेंट के साथ, और इनका एक छोटा सा एंगेजमेंट यहाँ पर हो गया, वो नहीं जाएंगे, नेक्स्ट टाइम आएंगे। Thank you, sir. You got the picture. What's your picture? You're leaving now? 4:30.
So I forgot to say one thing. We have got students from CSI Law College, Kanakari, and also SN Law College, Putota, that you can introduce.
Vinod Chandran sir is there.
Okay. I request Honorable Mr. Justice Vinod Chandran sir to kindly come over and accept our token of gratitude. ഓരോരുത്തരായിട്ട് ഒരു സെഗ്മെന്റ് ആയിട്ട്